for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Be seated, please. Case number 24-3016, United States of America versus Ralph Joseph Celentano III, also known as Ralph Joseph Celento III. Ms. Baumgartel for the appellant, Mr. Hill for the appellate.
Good morning.
Good morning. May it please the court, Sarah Baumgartel of the Federal Defenders of New York on behalf of Ralph Celentano, and I'd respectfully like to reserve 2 minutes for rebuttal. The court should vacate several of Mr. Celentano's convictions, primarily because the district court gave an erroneous defense of another charge, which went to the heart of Celentano's primary trial defense. The court should also order a resentencing. The government concedes that the district judge made multiple errors at Mr. Celentano's sentencing, and the only question is whether these errors were prejudicial. For the reasons that we set forth in our briefing, they are. With respect to the self-defense claim, the district judge agreed that a self-defense charge or defense of another charge was warranted in this case, but the charge that the court gave made 2 critical errors. It erroneously effectively instructed the jury that Mr. Celentano had to prove that the officer that he shoved, Officer Ellis, was using excessive force before he could claim self-defense or defense of another, but that reverses the burden of proof. In fact, it's the government's obligation to prove that an individual is not using excessive force. And even if Mr. Celentano were mistaken that the officer was using excessive force, he should still be able to claim defense of another. But the district judge's instruction misstated this law. The other mistake that the instruction made was that it asked the jury to consider the use of force from the perspective of the law enforcement officer. And as the government explained in its brief, as the government argues, this meant that their argument is that Mr. Celentano was supposed to consider the facts known to the law enforcement officer, and that should have been in his mind in order for him to be able to act in defense of another. But that's not how self-defense law works.
Would there be any difference between an self-defense instruction in a case where the person who was attacked assertedly and for reasons of self-defense or defense of another is a civilian versus a police officer?
There is a difference, yes. And so the case...
How do the instructions reflect that difference?
Well, the case law is clear that you can only use... the instruction has to say that the defendant believes that the officer is using excessive force. And so for an ordinary citizen, any use of force can precipitate defensive force. And so that's a critical difference. When the government talks about the right of self-defense being limited as to police officers, that's true. And the limitation is that there's this requirement that it be excessive force. But that doesn't answer the further question.
Does the jury know what counts as excessive force?
So they're supposed to consider it what they believe is reasonable under the circumstances.
I mean, excessive force has sort of a particularized meaning in the context of the law. And shouldn't the instruction at least inform the jury that excessive force, determining excessive force means more, I'm not talking about your perspective issue, but simply that it means more than force that could reasonably, that the defendant would have to think that the officer was using more force than reasonably necessary under the relevant circumstances. And there's a lot of circumstances that are relevant to deciding whether something's excessive force. And so it just struck me that the instruction proposed by the defense was sort of very simple and didn't seem to take account of informing the jury about its need to view force through a different lens when the person who was attacked was a police officer versus a civilian. Actually, your objections with their instruction was that it changed the perspective entirely.
Right.
But doesn't there need to be more information for the jury about what it means for something to be excessive force? To address the concerns the government has raised about not inviting everyone to interfere with every law enforcement officer engaged in the use of force.
Well, I mean, the problem, Your Honor, is that even if there needed to be an additional sentence in the defense instruction, the government's instruction was just erroneous. And so the government's instruction didn't provide the jury with any guidance as as to determining excessive force in the manner that Your Honor is suggesting. Rather,
Neither did the defense instruction.
well, I don't actually think that's necessary because it says excessive force. And if you drill down on some of the case law where they talk about it, it's what the jury believes is reasonable under the circumstances. And so,
I mean, this isn't something within the common ken of juries, what the definition of excessive force in the law enforcement context is.
well, but but that's the issue, is that it's not clear that the jury would need to find that it meets that definition in order
They
for
would have to
Mr.
find the defendant reasonably thought that it met this particularized standard in the law, and not just that it was a use of force.
I don't believe that's correct, because there you are expecting the defendant to have some specialized knowledge as to the laws, what constitutes excessive force. And that's not what
But
self-defense
then
law
otherwise, how do we
requires.
protect law enforcement officers from interference? Because at some level, there has to be some burden on the defendant to think that this isn't just the type of force that I could interfere with if it were a civilian engaged in it. We have to have, in your case, the defendant make a judgment before attacking that this is something outside the bounds of what the law allows a police officer to do. It's a different baseline.
And all the issues that Your Honor is raising are addressed by the reasonableness requirement. And so general self-defense says that the use of force has to
Requirement is
be.
no different than just instruction in a civilian case.
But that's right. But what's reasonable with respect to a police use of force versus what's reasonable with respect to a civilian use of force may be different.
My
But the
point exactly,
jury,
but the jury needs to be
told
that.
no, because the defendant is not expected to have specialized knowledge in order to
But
avail
then it
himself.
becomes the same standard as civilian self-defense.
But it
You either
doesn't.
have to tell the jury that it's a different standard. Now, it can still be from the defense perspective. That's a separate question, to be clear. But you have to at least inform the jury about the nature of what the person had to believe. They had to believe that it was reasonable for me to interfere with law enforcement, which is a different judgment than it was reasonable for me to interfere with a civilian who was beating somebody up.
And respectfully, all of that is covered by the instruction that the defense proposed and by the requirement that in the law that the defendant know the person is the police officer, for there to be a separate rule and for the actions to be reasonable under all the circumstances. And if the jury here had been given a correct instruction, then the government could have properly argued in closing, maybe this use of force would have been objectively reasonable against a civilian, but it's not objectively reasonable against a police officer for X, Y reason. However, the jury was not properly instructed. And to bring it to the facts of this case, here you have an officer in full riot gear repeatedly striking an individual with a baton. And so this is not a situation where the use of force was so obviously lawful.
In the middle of a riot where the people were running amok,
Your Honor,
trying to break into a governmental building.
whether you call it a protest or a riot, it's not licensed for police brutality. A police officer repeatedly beating
No,
someone
but it's
with
also
a
not
baton.
licensed for civilian brutality on police officers.
No, Your Honor, and that again goes to the reasonable use of force. And so that was all part of the defense instruction, that the force has to be reasonable under the circumstances. But in this situation, there's no requirement in self-defense law that the defendant consider the use of force from the perspective of the person against whom he's using force. That's antithetical to the concept of self-defense, because the idea is that, I think as Justice Holmes famously wrote, detached reflection cannot be demanded in the presence of an uplifted knife. Here we have an
And the Supreme Court has repeatedly talked about the circumstances under which a law enforcement officer must make decisions. And you don't say this in your brief, but it's undisputed that your client did not know the circumstances that were facing the police officer he attacked. Do you agree with that?
Yes, we agree that Mr. Celentano did not know all the things that Officer Ellis testified he knew. Yes.
So what does your instruction tell the jury? It says that if the defendant, although not familiar with all the facts, thought the officer was acting excessively, then the defendant can attack the officer?
No, Your Honor, but the gravamen of
No,
any...
but I'm trying to understand how it works from the perspective of your instruction.
that he has a sincere and reasonable belief that he's preventing excessive police force.
Here's what I'm getting at. An officer is in a chokehold. A second officer sees that, and the chokehold is being done by the rioter. And so the second officer takes action. Your client doesn't see any of that. All he sees is the second officer's taking action. So I'm trying to understand how your instruction, given that excessive force is just, force that's not reasonable under the circumstances, how it actually works. Because if your client testifies he had a sincere belief that the officer was acting excessively, is that the end of the question for the jury?
And his belief has to be reasonable under the circumstances. And so
leading to that, why isn't the error harmless?
So that's obviously an argument the government makes. In this situation,
And that's why I'm asking you to address it.
yes. In this situation, both Mr. Celentano and Officer Ellis testified. The video is quite equivocal. So the video that was presented to the jury, particularly the video from Mr. Celentano's perspective, you see Officer Ellis repeatedly striking someone. You do not see that person attacking another officer or putting another officer in a chokehold. And
Was
so
there
the jury,
any testimony challenging Officer Ellis's testimony as to that point, as to why he was acting in light of, I'm going to call this person, the third person, the rioters' conduct?
well, Mr. Celentano's testimony was that he couldn't see that. And so the point is that this is exactly why
He doesn't know what's happening. That's my point.
But
So he makes a decision about what is reasonable and unreasonable and excessive force by the officer. And I'm just trying to understand how the jury is supposed to parse this if it doesn't consider it from the officer's perspective in light of all the officer knows. Since excessive force is excessive under the circumstances. You may be right, but I'm just trying to understand, when I read your brief, I wasn't clear how your concept works in terms of, if I'm a member of the jury, what do I do under your instruction? Because you are going, as will any defendant, present evidence that he or she had an honest belief that the officer was acting unreasonably.
So certainly your Honor's question goes to the heart of why this instruction is prejudicial. So Ellis and Celentano testify. If the jury credited both of their testimonies and viewed the video evidence at trial, the jury could have easily concluded that it wasn't clear if Ellis was using excessive force, or perhaps he wasn't, but they could have credited Celentano that he didn't see this person with the chokehold, and so he believed that the force was excessive. Under those circumstances, Mr. Celentano should have been able to avail himself of this defense of another instruction. However, under the court's erroneous instruction, under those circumstances, the jury concluded that there was no self-defense available. That's exactly the problem with this instruction, is that if the jury credited the testimony of Celentano and Ellis, which was supported by the video evidence that the jury saw, they would have thought that Mr. Celentano was not entitled to self-defense, even though under a correct statement of the law, he should have been entitled to self-defense.
So even if we accepted your understanding of how the defense of another instruction should have been, even if we accept that, I mean, why isn't the error still harmless? Because it seems that it's highly probable that the jury could have concluded that the person the person that Officer Ellis was, was hitting, was the initial aggressor?
So the law is actually that Mr. Celentano would have had to know that that person was the initial aggressor, and there was no evidence that he did. So if the jury concludes that Mr. Celentano was truthfully testifying, which from his perspective on the video, you could easily conclude he doesn't know that this person is the initial aggressor. All he sees is a police officer in full riot gear repeatedly batoning someone. And so and again, the common law on this is very clear, is that a third party intervener may actually have a greater right to use force than an individual against who they're acting to protect if they don't know everything that that person knows. And again, I understand that some of this may be counterintuitive, but self-defense law is designed to protect defendants who act with a sincere and reasonable
I
belief.
understand, but we've also said it's really important in this context of attacking law enforcement officers, that the test factor in all the relevant circumstances to determining whether force was excessive. And your argument today seems to be the less the defendant knows, the more they're justified in attacking police officers. He didn't know who started it. He didn't know what the police officer was doing. He didn't know why he was hitting the other person. He couldn't see over the ledge. He just saw a police officer in the midst of a riot engaged in trying to control somebody and thought it was a good time to body block him.
Your Honor, not at all. Again, the stopgap is that a jury gets to consider whether or not the defendant's actions are reasonable. And so these are exactly the sort of...
You said reasonable under the circumstances, but the circumstances seem to be only what Mr. Celentano thought for a split second. And that gives no reality at all to the requirement that excessive force looks at all the circumstances in which the officer is acting.
No, for every self-defense claim, there's a subjective and an objective perspective. The subjective is the defendant's, and then there's an objective, reasonable person standard. And we agreed with that. That's what our instruction said. And these are exactly the sort of fact-intensive decisions that 12 jurors should be making.
No, but what exactly is your objective, reasonable person test? Because it would have to be a reasonable person unaware of all the circumstances.
No, not
arguing for. Yes, because you admitted he didn't know that in fact there was a person with a police officer in a chokehold right there. And that was one of the circumstances in which, that was the key circumstance that caused the officer to be striking the person with a baton. That's you would have to agree that's an incredibly relevant circumstance.
A defendant doesn't have to know everything the officer knows. The question is whether the actions are overall objectively reasonable.
No, but does a defendant have to take some time to assess the relevant circumstances? Otherwise, we're back to where I started, which is the less you know and the less you bother to learn, the more entitled you are to attack police officers. And that seems a troubling rule.
Not at all, Your Honor, but part of what you're arguing with is...
How does your test protect against my concern that the less he knew, he didn't know who was the initial aggressor. He didn't know why the officer was engaged in the behavior the officer was engaged in. He didn't bother to stop and think about it before attacking. And yet your argument is that's perfectly reasonable from his perspective.
Because there's always a stopgap that it has to be objectively reasonable. And so
no, you just told me objectively reasonable based on, you don't want it to be on the officer's knowledge. You don't want it to be on what was actually going on. You only want it to be objectively reasonable based on the facts that he had. Is that correct?
No, Your Honor. Objective is objective, but objective doesn't mean the officer's opinion. And that's the problem with the government's instruction.
Does it include the fact that there was a person in a chokehold, another officer in a chokehold that this officer was trying to free?
Well, the jury has to decide that. So if the jury credited that when Officer Ellis said it, that would be the first decision for the jury.
That seems inconsistent with your argument that it's really, even if in fact it was objectively reasonable, he could still have a reasonable belief that it was not objectively reasonable and be okay in attacking him.
Your Honor, our argument is very straightforward. There's a subjective and objective component. Subjective is what Mr. Celentano knew. Objective is a reasonable person, not the officer's own testimony about whether, Your Honor, the law's hypothetical reasonable person.
I mean, in this context, take this case, what would that reasonable person know? Would that reasonable person know that the officer was engaged in the use of force because another officer was in a chokehold and he was trying to protect that officer? Would the reasonable person take that into account?
That's a fact question for the jury. Officer Ellis testified that that's why he was striking this person. And so it's the
And
first
there's no
step for
counter
the
evidence
jury.
at all.
Well, Mr. Celentano
He
didn't
said he
see
couldn't
that.
see. That's all. That's not counter evidence.
No, Your Honor, but that's what I'm saying is that you're asking what would the jury be looking at? The jury would be deciding whether it credited this person's testimony as to why they were doing what they were doing. They would be looking at the videos. They would be making a decision about whether what Mr. Celentano did was objectively reasonable given everything that they saw. And that is a
Not clear to
really
me that's what the
fundamental.
defense instruction conveyed, because you've also argued that even if he was wrong and couldn't see and didn't know what was going on, as long as based on what he saw, he reasonably thought it was necessary to use force. So you're disavowing that position now.
No, Your Honor, but we've also gotten far away from the other mistake with the instruction,
No,
which
I'm
is
not.
that
I'm trying to understand your instruction. So let's stay on this question. Are you arguing? This is where I'm getting confused about what you think the reasonableness inquiry is here. Are you arguing that if in fact the jury credited Officer Ellis's testimony, but also credited Mr. Celentano's, that I couldn't see, I didn't know, I just saw this officer hitting someone with a baton, and let's assume if that's all we knew and that's all the facts that there were, reasonably thought that was excessive force, that he should
Sorry.
the instruction say that should be sufficient for him to be for a jury to find that he engaged in self-defense, even if somebody standing back the jury also credited Mr. Officer Ellis's testimony.
Yes, a defendant can avail himself of self-defense if he makes a reasonable mistake of fact. And so if Mr.
Without knowing all
Celentano,
the circumstances.
yes. And that
Then we are back to saying the less you know.
No, Your Honor, but the
You
self-defense,
can't say it's all of it, and you can't say that he still can have his defense without knowing. He can act reasonably without knowing the relevant circumstances.
Your Honor, I think your primary complaint is with self-defense law, not with our argument, particularly because self-defense law
This is a difficult
understands.
question on which I'm not seeing a whole lot of precedent on how we instruct a jury in the context of a decision to attack a police officer without pausing for a second to figure out what's going on.
There are many stopgaps, right? And so the first thing is there has to be an appearance that the officer is using excessive force. And so if an officer is using what any reasonable person would consider to be a non-excessive
That's right
amount
back
of
in the
force.
same problem here. Any reasonable person, or did your defendant reasonably believe?
No,
That's not the same thing.
Your Honor, because there are two inquiries, subjective and objective. And so
But your
the
client reasonably
stopgap.
believed are you calling that the subjective or objective inquiry?
So, but Your Honor's, I think Your Honor's concern is that the less you know, the better off you are. That only pertains to the subjective. For the objective component of the self-defense charge, which our instruction considered, the jury looks at all of the surrounding circumstances. And so, for example, and I write this in the brief, if a uniformed police officer tries to handcuff someone on the street, just puts them in handcuffs, the defendant, tried to claim, well, I thought that they were doing something unlawful. It would be very easy to see that that would be unreasonable. The defendant's belief would be unreasonable. And so there are many circumstances where no matter what the defendant objectively says, a jury might conclude that that was simply an unreasonable opinion. And so that's where the objective reasonableness comes into play. The problem with the government's instruction is that it went beyond simply objective reasonableness to suggest that the police officer's own opinion about his use of force should govern this question. And that's the problem. The second problem, of course, is that it suggests—
I suppose, though, the first problem, as you see it, is that the jury was required to accept Officer Ellis's perception. And I don't see that.
The government said that it was from the perspective of a reasonable law enforcement officer. And so the only testimony about the law enforcement officer perspective was Ellis's. And then the government further argued that the defendant should be essentially imputed to know everything that Officer Ellis knew. And so that's why it takes it beyond what would purely be objectively reasonable to a more subjective perspective.
Well, you want to use these words to bolster your argument, and I understand that, but I don't think it's helpful here where you're just putting subjective where it favors you and objective where it doesn't favor the government. So that's why we're pressing you on this, because this is not a context of a man on a street where the officer is trying to handcuff him. This is a riot where police officers were injured, one was killed. And in that circumstance, whose perspective should the jury first consider? And again, I'm back to where Judge Rao's question, why isn't any error harmless given the circumstances here?
Your Honor, truly, even if it is a riot, that does not give police officers license to beat someone.
No, but it does go back to the fundamental question of what do we expect of law enforcement officers? And Congress has repeatedly passed statutes with requirements, and the common law has requirements. And you, as I understand it from your instruction, want to reverse that by saying whatever the defendant thought, regardless of his basis of knowledge, if he thought the officer was acting unreasonably, then he was entitled to attack the officer. Isn't that what your instruction says?
No, Your Honor.
Why doesn't it? That's what I can't understand.
It says that he has to have a reasonable belief that the use of force was necessary.
It's reasonable from his perspective, because what he sees is the officer repeatedly hitting a rioter on the head. So from his perspective, as I understand your argument, all he did was to body ram the officer to stop. I mean, your client said, all I wanted to do was to get the officer to stop hitting the rioter on the head. But there's never any acknowledgement of the circumstances bringing the officer to the conclusion that was necessary. And that's what I'm trying to understand, what our legal system, as a jurisprudential matter, expects of the fact finder in a criminal case where we're talking about actions of law enforcement officers. And that's why all these cases that both sides cite, do not speak in a holding that makes it clear that we are bound one way or the other. And we're trying to figure out within our system what should be the rule if we have to even decide that question, or we can just say, it was harmless error.
I understand. I mean, I would encourage the court not to find it harmless because, again, the self-defense instruction was addressed by both parties. It went to the heart of Mr. Celentano's primary trial defense. The government specifically cited the instruction that we claim was erroneous, and so it was clearly an important part of the trial. I would also say that under the circumstances—
There's no question, but all the cases that sort of lean in your favor are just so distinct, where the defendant is essentially the victim of the police officer, and that decision has already been made.
I also, just to some of what else Your Honor mentioned, in terms of, the government cites 1983 cases, and there are obviously many doctrines protecting officers who use force. I think it makes sense to look at it from a different perspective here. Those are cases where we're determining the liability of the officer. And in those situations, it makes sense to consider the perspective of the officer to determine from their perspective whether their actions are reasonable. Here, we're considering the liability of Mr. Celentano, and that's why self-defense law has a different focus than the 1983 cases.
But we have to realize the consequences of a ruling would be when we say, you're opening the door to attack some police officers while they are engaged in the very, very difficult job of physically detaining, restraining, or halting a suspected criminal defendant. So I understand the liability shoe is on a different foot here, but the legal consequence of a ruling that says a jury could say, well, here are the facts Mr. Celentano knew, and given those facts, just those facts, he acted reasonably, even if those were not the relevant objective circumstances.
So many cases have recognized that there is a right to use self-defense against police officers, and there is a right to use self-defense in 111 charges. And so, but I understand your officer's concern, or your Honor's concern. I want to highlight a couple of sort of stopgap safety measures in this. You know, the government talks about the fact that self-defense against an officer is limited, and we agree with that. So it's not against an officer using any amount of force. There is this requirement that there has to be a belief that it's excessive force. Many of the cases the government cites also talk about basically the abandonment of the common law.
Does it have to be an informed, reasonable? You said a belief that it was excessive force. Obviously, I assume you meant
Right.
reasonable belief.
A reasonable belief.
Right.
A reasonable.
Does it have to be an informed, reasonable belief or uninformed?
So obviously that sounds like a trick question, uninformed.
I do
but
not mean that question. I'm really trying to test.
No, I know, but
my concerns.
uninformed in the sense that you don't have to know all the facts of the situation. Your
Right,
actions
and then we're okay.
have to be reasonable.
Uninformed. All right,
And
that
so-
clarifies for me.
You don't have the right, for example, to resist arrest. So that's established. I think most jurisdictions now have abandoned the idea that you have the right to forcibly resist even an unlawful arrest. And so we're talking about a very limited right where there's a sincere and reasonable belief that a police officer is using excessive force, and you may respond with no more force than is necessary, reasonably necessary under the circumstances. And so it is, in fact, a fairly limited rule that permits individuals, when they think they witness what is essentially police brutality, to take an action to stop that brutality.
In reply in all criminal cases. I don't know why it's limited.
Is that right?
And
Sorry.
You
I'm
said
sorry.
there are all kinds of stopgaps,
Yes.
and this is a very narrow rule that would
Yes.
only apply when a defendant is in a riot on the US Capitol grounds. I mean,
No.
this is a general rule about when you can come to the defense of another. That's what you're asking for. So this is not a narrow holding.
Well, Your Honor, I think it will probably be more sympathetic when the rule is applied outside of this context, frankly, because we've seen a lot of incidents of police brutality, unfortunately, in this country in the last several years. And so if you have a situation where a police officer is, for example, in New York, we had many protests after George Floyd's death. If you have a situation where in the context of a protest, even a protest that turns violent, where a police officer is viciously beating someone, there should be the right of someone to intervene.
No, and those cases where the courts have recognized where there's sadistic conduct by a correctional officer. I mean, you suggest that the instruction that was given abandons the defendant's right to show that an officer was acting excessively.
No, it reversed the burden. So even though the law should be clear that it's the government's burden to prove that the officer was not using excessive force, it suggested that before even considering Mr. Celentano's claim, he had to show that the officer was using excessive force. And our argument is that's not correct because he could have been mistaken, or the jury could have been unsure if he was using excessive force, and he still should have been entitled to avail himself of self-defense. I see that I have gone way over, and so I apologize. I would answer any questions related to this sentencing. I would just urge the court to remand the case for resentencing. It was an extremely complicated sentencing, and the government concedes that there were a number of errors. And in this context, it just makes sense to give the district court another
Let me
opportunity.
see if my colleagues
Well,
have
but
any.
the district court already told us what he would do. So you have to win on your instructional error, don't you?
No, Your Honor, The district court made a very specific statement that he would impose the same sentence if one issue was different. But in fact, there were several errors. And so I think there are a number of errors the district court, including just the consideration of the 1512 charge, of which Mr. Celentano was acquitted and which now I think the government agrees under
And the
Fisher.
district court was fully aware of that.
No, Your Honor, that was before the Supreme Court's decision in Fisher. And so at the time, I think the district court was acting under a misapprehension as to the law on that. And then just because the number of issues, we asked for a remand for resentencing.
Any more questions from my colleagues? Judge Rogers, do you have any more questions?
No, thank you.
Thank you very much,
Thank
counsel.
you.
We'll still give you 2 minutes for rebuttal.
May it please the court. Dietrich Hill on behalf of the United States. The instruction given at trial fairly stated the law on Celentano's defense of another self-defense claim. Self-defense in this context is more limited because the police are different. We apply different standards to the use of force by the police. Both sides agree in this context that Mr. Celentano had to have an actual belief that the police officer was using excessive force. And the question is just how to assess the reasonableness of that belief. We should assess the reasonableness of that
Your
belief.
instruction required the jury to find that it was excessive, that intervention, shall we say, the intervention was reasonable in the view of the police officer and not in the view of the defendant.
It required, in some sense, yes.
In some sense, no, how about like in terms?
Well, it required the jury, one element of the self-defense or defense of another defense was that the police officer had to be using excessive force from the perspective of an objective police officer. In other words, an objective police officer would agree that this force was excessive. Now, that didn't reverse the burden, as opposing counsel contends, because at the end of all of those instructions, the district court made clear to the jury.
It's a completely different perspective than what the law has always been for self-defense, which is you view the right to intervene from the perspective of the defense. Was it reasonable for the defendant to conclude?
It is a
excessive
different
force?
perspective.
And what yours is, did the officer who was engaged in clubbing the other person think it was, would a reasonable officer, did that officer reasonably believe it was excessive? So this is a total shift in perspective.
It is a shift in
You have
perspective.
no cases to cite for it.
Well, no,
You're citing 1983 cases. You have no court that's ever adopted instruction like this?
we have, well, the closest case that we've seen is Branch from the Fifth Circuit, which squarely holds that you get a self-defense instruction in a Section 111 case only if there's evidence of excessive force as viewed from the perspective of a reasonable law enforcement officer on the scene. That's the closest case in the 111 context. There are a number of other cases in the 111 context that are somewhat ambiguous on the point. They say there has to be a reasonable belief.
Why isn't it sufficient to keep it, the question, from the perspective of the person who engaged in self-defense?
Because
But inform the jury what the relevant framework for analyzing that is, instead of shifting it over to this impossible question of how a defendant is supposed to know what the reasonable officer, knowing all kinds of facts that the defendant doesn't know, would think.
an objective,
Impossible. I don't know how that ever happens.
right, an objectively reasonable person is often not going to be equipped either because they're just a civilian or because they don't have all the facts to make an assessment of whether the officer is using excessive force. And to be candid, that means that sometimes a person can make a mistake that in some sense is objectively reasonable from a non-police officer's perspective and still be liable because the police officer was lawfully using force. But the point of that is to protect police officers.
You want actual unlawfulness.
Effectively, yes.
But self-defense is never, I mean, it's just been pretty well established that as long as the defendant reasonably believed that the use of force was necessary, if it doesn't matter that in fact, you got the facts wrong.
Right.
That's always been the standard.
In the ordinary
And it's not
case,
necessary to protect police officers to go that far as long as one were to instruct the jury on the appropriate framework in which to analyze objectively whether one could reasonably conclude that excessive force was being used.
there are a number of jurisdictions that support us on this point, including DC, which is the most common jurisdiction, as I read it, cited in the defendant's brief, which says that in an assault on a police officer prosecution, you get defense of another only if there's actual excessive force. You can't make a reasonable mistake about whether there's excessive force. And that's also consistent with the common law rule on resisting an unlawful arrest. You had to be right. If you made a reasonable mistake about whether the...
How is that consistent with the common law understanding of self-defense in general, right? That it's a justification for what someone did, which means that it has to be from the perspective of the person engaged in the action.
It is a different rule than the common law as applied to ordinary people and not police officers. We're asking for a different rule. We think that's correct in this context. There should be a special rule for police officers that says that you look from the perspective of a reasonable police officer.
Why isn't it sufficient, though, for the reasonableness standard to take into account the particular context of the fact that it's a law enforcement officer?
That's the alternative standard, but this is the more protective standard. And it doesn't seem fair to put a police officer in the position of using force that a court would later agree is objectively reasonable, and yet expose that police officer to attack by a civilian who doesn't necessarily know all the facts, and they're coming at it from a different perspective. In this case, of course, one of the reasons that we think any error
It's only
was...
going to happen if an objective person viewing all the relevant circumstances would conclude that the force was excessive. So we're not talking about protecting law enforcement officers generically. We're talking about how to strike the balance, protecting officers engaged in the use of force when objectively a reasonable person familiar with all the relevant circumstances would conclude that the force is excessive.
Well, it's not a reasonable person familiar with all of the relevant circumstances, as Your Honor alluded to earlier, because they, under the defendant's view
No,
here...
that be the defendant's one, but I think Judge Rao was asking about informing the jury what the relevant circumstance, what the framework is for analyzing this as part of the reasonableness inquiry. And so as long as the jury is informed as to how excessive force needs to be analyzed, it's not just a layperson standard. And they would have to determine that under the relevant circumstances, the force was excessive. From the viewpoint of a reasonable person.
This puts the burden on a civilian observer to find out all of the circumstances known to the officer and then to assess whether the force was excessive from an officer's perspective. If the civilian can't do those things, he or she should not be intervening and violently assaulting a police officer.
There's a risk here of tipping the balance too far the other way, because there are plenty of situations, I don't know if there's plenty, there are situations where in fact police are engaged in excessive force. And intervention might have saved an innocent life.
And
but if we say, oh no, don't take any risks unless you've done your legal research and have a lawyer advising you that this is excessive force, don't intervene. I mean, there needs to be a relevant balance here, and the self-defense balance has always stopped short of requiring that in fact what the other person was doing was unlawful.
Well, and we agree that if the police officer is using actual excessive force, there is a defense of another defense available. This is...
Person reasonably informed could a reasonably informed person reasonably conclude that it was excessive force is different from whether it was excessive force.
It is different. I'm just pointing out.
Why is that margin the one why do we need to go beyond the way I've articulated it and protect that extra margin?
Because there is this gray area where we don't want police to be using legal force and still subjected to violent intervention that the law protects. And the police officer is going to know, oh, I'm using reasonable force, but a person who can't see the hands of the person I'm using force against, can't see that they have a knife,
Mr. Hill.
could come along and
but-
assault.
But isn't our jury system premised on the notion that reasonable people who have been through voir dire can make a judgment if they are instructed on what factors need to be taken into account? My concern, as my questions to counsel for appellant indicated, I'm just not sure how this defense of another works, in fact, under either party's instructions, because any officer is going to testify that based on his training and experience, what he did was reasonable given the facts he knew. I mean, it'd be a rare case that that doesn't happen. So too, in my view, as a former prosecutor, it's going to be a rare case that a defendant will not say, even when the officer is putting on handcuffs, that the officer used excessive force. So where does that leave the system we have? And I thought that's what my colleagues' questions are getting at. And I understand from the government's perspective why it's favorable to have the instruction that was given. But I don't know that that's consistent with sort of the history of what the role of self-defense was all about. Namely, when some person is attacked by organized forces of government, what's your defense? And you may not know everything, but from your perspectives, seeing any officer under any circumstances, as I understand the argument here, hitting somebody repeatedly on the head with a baton is a reason to try to take what, from the defendant's point of view, was reasonable action to stop that. And the jury can reject his defense on the grounds that he was totally unaware of this second officer being held in a chokehold by this rioter, and we're in the midst of a riot. That's what I'm concerned about. And I think that's sort of what our questions are getting at. It's easy to see why each side wants the most favorable instruction, but what is it doing to the system and how we have conceived of it through the common law and, of course, through the statutory law as well, in terms of our procedures and what defenses can be raised by a defendant at trial?
Right. I think I have three responses. First is simply that there could be hard situations in which, for example, expert testimony was required to determine whether an officer was using reasonable force. I don't think that is this situation. There's no real evidence in the record that there was, in fact, excessive force from the perspective of a reasonable officer. Second, thinking about the common law, there are jurisdictions that support this test that the government is asking for. And there is the common law of using force to resist, as I said before, an unlawful arrest, where if you were wrong, even if you were reasonable in thinking that the arrest was unlawful, you were criminally liable for assault. So you did so at your own peril, as a number of cases have said. Third, this is a matter of federal common law. It's a federal common law defense. And so to some extent, the court is looking at the real world consequences, as well as Congress's intent in enacting Section 111, which, as the Supreme Court put it in Viola, is to extend maximum protection to federal officers.
Mr. Hill, is this position about defense of another, has the Department of Justice been taking this position consistently across civil disorder context, or is this a position that it's taking in the context of these January 6th cases?
I have not seen, it's certainly possible that some brief somewhere has addressed this before. I have not seen a general position. I have not seen a brief that addresses this exact question. I can tell you, in fact, that more recently we have taken a more conservative instruction on the belief that we can win almost all of these cases with a more defendant-friendly construction like that proposed by the defendant here. But frankly, we think this is right in any case. And this is in some ways not the most dramatic case. The worst case is the situation where somebody is threatening to use lethal force on an officer. The officer has his gun drawn and the third-party intervener can't see why, and is going to tackle the police officer and put everybody's life at risk. That is going to escalate the situation. And that's why in these difficult cases where a civilian is not equipped generally to know when a police officer, whether a police officer should be using force, we want to discourage intervention.
When you say this is a government position, is this one considered within main justice, including consultation with the Civil Rights Division, which section that prosecutes crimes against police officers for unconstitutional conduct?
No, we did not consult with
So
them.
this is just your office's position.
Yes, and I
I
apologize.
thought the question was the government's position.
Right, I apologize if that was unclear. To my knowledge, there's no main justice position on this, and I could be mistaken about that. But I do think this is consistent with.
So we could be buying a position that the Justice Department might not be willing to defend
Well, I think this
on
is.
further review after consultation with the Civil Rights Division that sees, at least a section of it that sees the very different side of police officer conduct.
To my understanding, though, this position is the same as taken in both the 1983 cases and prosecutions against police for police brutality, which is from the perspective of a reasonable police officer. Should the police officer have been using force or that degree of force in that
It's about the
circumstance?
culpability of the officer, where here we're talking about the culpability of someone who stepped in to defend another person. Their culpability. I mean, it's a different perspective.
It is a different perspective. And again, to be candid, we're asking for a rule here that's specific to police officers because the law has rules that are specific to police officers. They use a different degree of force and they use force under circumstances that ordinary people could not, and circumstances where an ordinary person might not even be able to assess whether the use of force is appropriate.
Can I ask you a question about the double jeopardy?
Yes.
So Section 231A3's requirement that a civil disorder affect commerce or the performance of a federal function seems to be a jurisdictional element. And there is a split in the circuits about how a jurisdictional element of a crime should count for the purposes of the Blockberger analysis. So I'm wondering, to rule in favor of the government on double jeopardy, do we have to reach that circuit split?
No. And I guess I have two responses. One is that there's another element that's clearly distinct, which is the performance of the officer's duties during a civil disorder. And as this court held in Stevens, these offenses are clearly other than one another. But also the real point of the Blockberger analysis is that in order to prove the Section 111 violation, we didn't have to prove anything about the 231 because we could prove the felony Section 111 violation purely by proving physical contact. We charged that and we did prove it that way, which is why there's no hard Blockberger question here.
Well, do we look at Blockberger after the fact based on the conviction, or do we look at it up front based at the time of charging?
Ordinarily, I think the court looks at it up front. In this case, we're not contesting that. Essentially, we look back to determine what the other felony was. Normally, for example, in a felony murder case, the government would charge, murder in the course of a robbery or something. Here, it charged murder in the course of another felony, but we're not contesting that after trial, we should treat that other felony as the actual felony that the jury concluded there was intent to commit.
I'm trying to understand how do you have any authority for us applying the Blockberger analysis at essentially the tail end of the case, based maybe on jury findings, since you had the two alternative grounds here, and specific findings, and not applying it up front when you charged 111, and intent, one option of which was intent to commit another felony, which necessarily brought in all the elements of 231, since that was your other felony.
Right. It doesn't matter here because we charged the alternative physical contact up front and we proved
Why doesn't
it.
it matter if we're looking up front? If the jury had come back and not found the physical contact portion, had only found the intent to commit a 231 felony, would there then be a Blockberger problem?
Then we would reach the very difficult question of whether one of the section 111 verbs, such as resist or oppose, always constitutes a substantial step for purposes of the attempt theory 231.
When would it not?
Frankly, Your Honor, because Blockberger is an entirely hypothetical test based purely on the elements, you have to answer some very difficult and weird hypotheticals about.
I'm trying to understand what the position of the government would be if the jury had come back with a no on the physical contact alternative for 111. What would the answer to Blockberger be? I understand it might be a difficult analysis. What is the government's position as to what the answer would be then?
We haven't formally formulated a position. My instinct is that we would still argue that there's no Blockberger problem because there are conceivable ways to violate section 111 that a jury could rationally
It
conclude.
wouldn't count as a step towards interfering with a,
I think in most cases, in most practical cases, we would argue that whatever the offense was that was committed under section 111 also constituted a substantial step. The question is just whether you can think of any conceivable way to violate section 111 that would not constitute a substantial step, which is why you get into weird.
if we do Blockberger up front, why don't we have to do that difficult analysis here rather than relying on the post hoc fortuity that the jury found both prongs satisfied?
Here, if you do Blockberger up front, then it's even easier because it didn't matter whether we proved physical contact at all. And in fact, normally it's the special verdict here that makes things odd.
Sorry, you're saying it doesn't matter that it's irrelevant whether you prove physical contact if you're doing it up front? Why? That's exactly the hard question you said you didn't want to answer.
Right. Well, because ordinarily there's no special verdict form. So if you charge two
Well, I
alternative,
understand. I'm very confused about your answer because I'm asking you if up front, we don't know how the jury's going to come back. Let's assume you're planning to do a special verdict form at least to help you out with Blockberger. We don't know how the jury's going to come out. So why don't we have to do that difficult analysis of whether your 111 claim that specifically charged as being predicated on committing the other felony, 231, is not a double jeopardy problem? Why don't we have to decide that?
because we also indicted on physical contact. So because we indicted.
We don't know what the jury's going to do. And you said if the jury,
Right.
you don't, at the front point where you're doing Blockberger, we don't know the jury's coming back. And you've said if the jury doesn't come back on physical contact, we got an issue.
If
we have to do it up front, why don't we have that issue now? Why don't we have that same issue, look at it without yet knowing how the jury's coming back?
Because if we do it up front, I do think that's the easiest case because we charge physical contact. And if we get an ultimate jury verdict, we know that the government actually didn't need to prove, and we don't even know if they did prove intent to commit the 231. We only know they proved one of the prongs. And so we definitely,
found both, so we know what the government proved.
in this case,
And
we
what they
proved
found.
both. Yes.
And if it's a very difficult question about double jeopardy, we know that he very well may have been put in jeopardy to the extent the government pursued the commit another felony prong theory.
No, there's no double jeopardy problem because we charged and proved the physical contact prong. So the government did not necessarily or invariably have to prove the 231 intent. And so there's simply no double jeopardy problem.
Mr. Rogers, do you have any other questions?
No, thank you.
Thank you very much.
Great. We would ask the court to affirm.
Okay, Ms. Baumgartel, am I saying that right? Gartel?
Close enough. Baumgartel.
Baumgartel, I apologize.
It's
Give you
okay.
2 minutes that you asked for.
Thank you. I mean, just briefly, I believe as Judge Rogers mentioned, our first issue is actually unsettled. I mean, I think the government said that branch from the Fifth Circuit squarely holds their way. That's not right. I mean, that was a case where the court was affirming the refusal to give any self-defense charge in a very different context. Same for DC. And if you drill down on a number of the cases that the government cites, there is not actually a case that holds, and there's certainly not a consensus that you have to charge this perspective of a reasonable officer. Just with respect to the government's argument that special rules should apply to police officers, I just want to highlight that even the government agrees that The self-defense rules only change if the defendant knows that the individual is a police officer. And I think that really underscores that even when we're dealing with the use of force against people who are police officers, it's fundamentally the defendant's own perceptions that govern a self-defense claim. And so if you have an undercover officer, the government agrees if the defendant doesn't know the person's an officer, they may be entitled to use the same amount of force as in any other context of self-defense, which I think supports our argument that it fundamentally comes back to the defendant's perspective. The final argument I'd just like to make is that these are extremely fact-intensive questions about when it is reasonable for an individual to use defensive force, and they are the sorts of questions that are truly best left to a properly charged jury to hash out the facts and to decide whether, in their opinion, as the conscience of the community, the defendant's actions were reasonable. And so that's why our instruction would have been sufficient here, and this should have been a jury question. Thank you.
Any other questions? All right, thank you very much, counsel. The case is submitted.
Case number 24-5049. John Doe, appellant, versus Jonathan McKernan in his official capacity as Director of FDIC and Federal Deposit Insurance Corporation. Ms. Lichtenstein for the appellant, Ms. Lyons for the appellees.
Good morning, and may it please the court. Alexandra Lichtenstein for appellant John Doe. The district court abused its discretion in denying Dr. Doe's motion to proceed under a pseudonym. On factor 1 of the test, it failed to account for the particularly heightened interest an individual has in a criminal record that has been pardoned and sealed and removed from the public record. On factor 4 of the test, it departed both from the way that factor has long been understood as focusing on reputational harm to the defendant, and from this court's reasoning in its 2020 In Re Sealed case decision, which focused on the importance of a plaintiff's identity to understanding individualized government determinations. Instead, the district court read this court's In Re Sealed case decision to establish a decisively heightened public interest in suits like the one here, which raise purely legal issues about the constitutionality of a statute. And in evaluating the public interest, the district court further failed to consider whether a pseudonym would actually impair the public's ability to understand the case. Because it does not, and because he has an especially strong privacy interest, the district court abused its discretion in denying Dr. Doe's motion to proceed under a pseudonym. First, the court failed to acknowledge the nature.
Ms. Lichtenstein, so as you've already said, the standard of review here is abuse of discretion. But from what I can see, you only cite one district court case in which someone with a sealed conviction was allowed to proceed with a pseudonym.
Your Honor, I believe there are a few different cases in which courts in other circuits have allowed individuals with expunged convictions to proceed under a pseudonym. So there is an example, Doe's 1 through 8 v. Sturdivant. I believe that's from Louisiana. There's also a case from Ohio. So there are many situations in which courts have acknowledged that there is a particularly heightened privacy interest in criminal history information that's sealed.
It does seem, though, that the privacy interests that we usually are focused on are different. They're about, sexual crimes or related to personal matters like that. So how is this similar to the sort of the heartland of those cases?
This sort of information falls exactly within the heartland of that sort of information. So as we explained in our briefing, those sorts of bits of information are categorized as particularly sensitive because they are highly stigmatic and would otherwise not be known to the public.
The difference here is that they wouldn't otherwise be known to the public, whereas here, the fact of a criminal conviction is, because we have thankfully public and open, transparent criminal proceedings, known to the public. The governor's decision to grant a pardon is itself a matter of public governmental record. There was newspaper coverage because we have a free press in this country that can cover criminal prosecutions. So this is very different. This is much more like Microsoft when we said, we're looking to whether something has previously been subject to public exposure. And the examples that Judge Rao gave are things that are traditionally kept intimate and secret. Whereas here, the difference is, even though it's later sealed, expunged, it has been a matter of public record, and the decision to seal, expunge itself is a matter of public record. And so we have to find a privacy interest here now, not just because something's stigmatic, but because it has some inherent claim to being private, and it's hard to do that with criminal conviction matters.
I think there are two answers to that, Your Honor. The first is that that's true in many circumstances, but it's not true in the circumstances of this case. So Dr. Doe had his record pardoned and sealed. It has faded.
The governor's decision to make that pardon was a matter of public record and is a matter of Ohio governmental record.
So
Records.
In Ohio, a decision to pardon is itself sealed. And Dr. Doe has made significant efforts over the years to ensure that information about his
I'm sorry, was
conviction.
it not a matter of public record when the governor granted the decision to seal? The governor's secretly deciding?
The governor is not secretly deciding,
That's a matter
but
of public record.
records relating to the pardon under Ohio law are then themselves sealed.
After the decision's made.
After the
First,
decision
decision is disclosed to the public.
That's true, but
Okay, so it was made a matter of public record. And in this day and age, once a matter of public record, always a matter of public record.
that may be true for many people, but it is simply not true for Dr. Doe. So as he wrote in his declaration, he has invested
I understand he said it
significance.
after the fact, but again, we're talking about facts here. Normally, someone's sexual history, medical history has never been a matter of public record.
So I think
You're in a very different position here where, for very salutary reasons, both the criminal conviction and the fact that a governor has decided to pardon/seal a record are both matters of public record.
So again, Your Honor, I would push back that those are still available to the public
Still,
if
but they
you,
were at one point.
certainly. And so I think that would take me to the
Isn't true of the
second.
other examples.
Sure. So the second response to Your Honor's question is that criminal history information has long been recognized by the Supreme Court and by this court as information in which there is a significant privacy interest, even though that information is true and may be a matter of public record or have one time been a matter of public record. So in Reporters Committee, the Supreme Court made clear that an individual has a significant privacy interest in his criminal history information, and that interest is all the stronger when the passage of time or their efforts to maintain privacy have rendered that information inaccessible.
That was a statement about compiled rap sheets that back at the time made could only be put together through extraordinary effort. And so the reality of their existence in the world was itself essentially secret because it was so much work to try to compile rap sheets. It wasn't the fact of a single conviction, let alone a proceeding by a state governor. It was an issue there.
I think the Supreme Court's language was a bit broader, Your Honor, and they did acknowledge that there is a significant privacy interest in one's criminal history. But in this court's decision in ACLU 1, which did not focus on these sort of compiled rap sheets, but instead on the fact of conviction, this court recognized that there is an individual interest, a privacy interest in the sensitive information surrounding a conviction, and in ACLU 2, recognized that that interest is all the higher when it would unwarrantedly associate an individual with a criminal history.
Well, then that your unwarrantedly adverb that you used there also seems relevant to this case, because what do we do if the identity of the person And the thing that they wish to keep sealed, their association with criminal activity, seems actually quite pertinent to the public interest of understanding the nature of the litigation, right? This is an effort to invalidate an act of Congress passed by both houses, signed into law by a president of the United States. And one person now wants to declare facially for everybody that the statute that says the FDIC cannot hire people with felony records is unlawful. Doesn't the public have an interest in knowing, in a way they may not in other cases, what it is and what the relevant criminal activity is of the person who's bringing that challenge?
So as the Ninth Circuit recognized in Doe's 1 through 23, there's kind of a two-step inquiry about the public interest. The first is whether the public might be interested in knowing the outcome of the case, that it's a matter of widespread public importance. But the second, which the district court failed to consider at all, is whether the public interest would be impaired. That is, whether the public would be unable to understand or follow the case simply because the plaintiff is using a pseudonym. And here, that's simply not true. The plaintiff's name is a very minor piece of information. It is not.
The fact is that he wants to say, and we're not getting to the merits, maybe he's right, maybe he's wrong, but he wants to say that it's unlawful across the board for Congress and the president to have decided the FDIC should not hire people with felony records. And it might make a big difference, the public's understanding of that, to know if and this is all hypothesizing, but if the person bringing the lawsuit had a history of bank fraud. That would really factor into their calculus, as opposed to maybe a history of littering, or had a history of, violent behavior. For a facial attack, all of this is relevant. And so it seems to me, you might say the name doesn't matter, but knowing the name of the person and the nature, the conviction that person did and their history, knowing something about them may have more relevance here than it would in other cases, would it not?
So, Your Honor, I don't think that is true for several reasons. The first is that that's not relevant to the merits of Dr. Doe's claim. And what
Why is it appreciating who these felons are that he says should be hired, should not be barred from being hired, are and what they've done? Why isn't that relevant?
So the question that is brought by Dr. Doe's merits case is whether there is any rational basis for a flat categorical bar on any individual with any felony working at the FDIC.
Yeah,
and
but
so
under a facial challenge, if the government can identify one instance in which it would be a rational application of the rule, then the facial challenge fails. And so understanding who the plaintiff is, what their motivations might be, allowing the public to decide what their motivations might be, what that person's history is, seems much more relevant than it does in many other cases. And so how do we factor that into the nature of the balancing analysis, that public interest?
So, Your Honor, the government is free to raise those arguments at the merits stage, but in looking at whether the plaintiff should be allowed to proceed
I'm talking
under
about the public interest and understand. You said an unwarranted public interest, and I'm pushing on that.
Sure. So what courts have consistently held, and in fact, this court held in Ray Sealed case 2, the 2020 decision, is that the public's interest is in being able to understand and follow the case and to understand how this court's opinion
Themselves from the rules that govern everybody else. And here he wants to accept himself and everybody in the felon status class from a rule that Congress adopted.
So, Your Honor, I think that's actually quite different than the sort of exception being discussed in Ray Sealed case 2. Here, Dr. Doe is bringing a challenge to the constitutionality of a statute, and that challenge would apply equally to everyone affected by the statute, depending on how.
Is he bringing in facial challenge, or is he bringing facial
He's also
as applied?
He's also bringing that.
Well, the as applied one would very much be a singular exception, just like in Ray Sealed case 2.
But it doesn't turn on any factual issues.
I'm just back to where we were in Sealed case 2, which is his as applied challenge seeks an individualized exception for him from a general federal requirement.
An as applied challenge would, based on the facts that are already in the record, challenge the law as applied to him, but that would be, again, a purely legal question. There aren't issues of credibility that might come up. There aren't disputed factual issues. And as this court held in Ray Sealed case
You don't
2,
have you get to proceed pseudonymously if you're only raising legal questions rule.
so the Second Circuit in Sealed Plaintiff v. Sealed Defendant held that there is an atypically weak public interest when
That may be what the Second Circuit held, but someone's trying to invalidate either facially or as applied a federal statute in this case. And particularly if they're seeking a singularized exception for themselves, I don't know how you get out of Sealed case 2.
so
On that fact.
Your Honor, I think that when you read in Ray Sealed case 2 in context, it was referring to a petition for review from an individualized agency adjudication in which the government was acting as a regulator. And the challenge to the law it was bringing was the framework for exceptions for which the public didn't have a real interest in knowing the plaintiff's identity. It might have been relevant to the plaintiff's market share, to competitors who might want to know how exceptions might apply to them moving forward. But here we have a purely legal question. Dr. Doe is bringing a challenge to the constitutionality of a statute, and it doesn't aid the public interest in understanding whether or not that statute is constitutional to know his identity. And in fact, as we pointed out in our briefing, there is a public interest in having the constitutionality of laws challenged and in pressing laws to ensure that they are constitutional, and in ensuring that when the only class of plaintiffs able to bring that sort of challenge are those who...
There seems to be no shortage of people in this country who are willing to bring constitutional challenges to statutes in their own name.
That's certainly true.
I don't think we need to have a secrecy policy just to encourage policing of the constitutionality of federal laws.
It's not simply to encourage that, Your Honor, but as courts have held, when the class of individuals able to bring those sorts of challenge are subject to stigmatization and are part of a disfavored minority, there's a heightened public interest in ensuring that those individuals are not deterred from bringing that sort of challenge. And that's the situation that we have here with Dr. Doe, who has, again, particularly heightened privacy interests in a criminal history that no longer exists as a matter of Ohio law. The criminal information was pardoned, it was sealed, and it is no longer part of the public record.
At the time he applied to the FDIC in 2022, Ohio law allowed an employer to ask him about this very criminal conviction and for him to answer honestly.
So Ohio law in 2022 would have kept that information secret, and
It allowed an employer to ask and he had to answer. So it did not say in 2022, you have a privacy interest in telling the employer no convictions. Changed that later. But in 2022, when he applied to the FDIC, the law was that he didn't even have a right to keep the secret from an employer who asked.
So in 2022, Your Honor, under Ohio law, this conviction was treated not to have occurred. And so I do think Dr. Doe would be within his rights not to affirmatively offer that information to the employer or not to check yes.
They changed it in 2023. They changed the law in 2023, but in 2022, employers were allowed to ask.
So, but Dr. Doe didn't have to affirmatively offer that information, and were he asked...
It offers a very different thing. I'm saying for the level of the privacy interest here.
But the employer would have to ask very specifically whether he had a conviction that was pardoned and or sealed. If the employer simply...
Do you have a case that says that? At that time, that's what they meant when they said it was still okay for employers to ask.
I'm not familiar with an Ohio Supreme Court case from that time.
I'll take a lower court Ohio case.
I don't know any off the top of my head, Your Honor.
We don't know that, in fact, they'd have to ask a specific question. We don't know that at the time they couldn't say, tell us if you have any felony convictions.
What I do know is that as a matter of statute, Ohio law said that those convictions are treated not to have occurred.
There were exceptions.
And exceptions mostly limited to the law enforcement context. So if he were convicted of an additional crime or for the purposes of a background check for a firearms permit, for example.
So if the
But-
FDIC was hiring him for purpose of its investigatory arm that looks into violations of banking laws,
Would he be required to provide that information?
would we say okay for them to ask?
So FDIC is obviously not governed by Ohio law and it's hiring in DC.
No, but you think Ohio law wouldn't even treat it as something he's entitled not to disclose.
Ohio law does treat his conviction as
It was
something.
for law enforcement investigatory purposes.
So my understanding is that it's for very limited purposes around like sentencing after an additional conviction or very narrow law enforcement
Yes,
positions.
and I've asked if FDIC was hiring him for a law enforcement position within, maybe civil law enforcement, within FDIC.
Sure. So FDIC would
Okay,
be
I mean,
able.
You brought a facial challenge here, so.
Sure, and that might go to the merits of Dr. Doe's claim, but I don't think it undermines the serious privacy interest he does have in this information. In granting a sealing of the
Well,
record,
it draws into serious question how private that interest is if Ohio law is leaking around the edges here and making it perfectly permissible and requiring him to honestly answer, that his answer that it never happened doesn't work, is not allowed. He has to acknowledge it happened in certain law enforcement hiring contexts and other law enforcement contexts. And it was okay for employers to ask the question, at which point he must give an honest answer if he wants to be employed.
so
There's a lot of leak around this privacy interest.
So, Your Honor, I think it's important to recognize that this privacy interest is not a binary, it's a spectrum. The fact that Dr. Doe may have been required to reveal this information to a few select individuals is a much more minor infringement on his privacy right than linking his name in the caption of this case such that it's available to anyone who would do a web search for his name. And the fact that he has kept that information out of the public eye, out of being linked to his name, that as he wrote in his declaration, almost no one in his life is aware of his previous convictions, that all goes to the strength of his privacy interest and to the degree to which it really has been kept confidential. The fact that
So is your position not just that Ohio law is what defines or sort of identifies a privacy interest here, but it's Ohio law plus his efforts?
that's correct, Your Honor. So
We had someone who had their conviction sealed just like he did by the governor of Ohio, but this was a poor person who didn't have the resources to take all the steps that Dr. Doe has done here to kind of layer on secrecy over his prior conviction. That person might not be in the same place and would not be able to proceed pseudonymously.
it may be true that the individual facts of a case and the extent to which that information is public would affect the degree of privacy and sensitivity of that information. I don't think that is.
Imagine how difficult we would find it to be to write an opinion that would say those who have enough resources to invoke services that hide your information better are entitled to proceed synonymously, but those who are in equivalent legal position but don't have those financial resources would be treated differently?
I don't think it's just a matter of financial resources, Your Honor. Dr. Doe has personally and individually invested significant amount of his time in hiding.
People who are poor don't have time for that kind of stuff. They're working jobs.
It may be true, Your Honor, that different individuals are positioned differently to be able to keep this sort of information secret, but that is the kind of interest that the pseudonymity test weighs. The question under factor 1 is the degree to which this information is highly personal and sensitive. And as the Supreme Court explained in Reporters Committee, that degree of sensitivity does rest in part on how confidential that information has kept. It may be that the passage.
Objective inquiry, sort of categorically across the board, how society views that information, like the examples Judge Rao gave? Or are you saying it's a individualized inquiry to how secret the defendant has kept the information, or the would-be plaintiff has kept the information?
I think both inquiries are relevant to factor 1, Your Honor. So what the factor distinguishes between is information that's highly sensitive and information that might cause mere criticism that might attend any litigation. And so relevant to the sensitivity is both the degree to which it has been kept highly private, but also the degree to which the public treats this as a matter of stigmatization. And in Dr. Doe's situation, that level of stigmatization is particularly high because it is unwarranted. He is no longer, in the eyes of the law, considered someone with a felony conviction. And so being put back in a position where he would be considered to be associated with criminal activity in an irreversible way would undermine a serious privacy interest and not just subject him to the normal sort of criticism that might accompany any litigation.
Let me just be clear about sort of one sort of technical factual situation. The fact that his motion has been denied, if he decides to go forward, is he in a position where he can still have the record sealed before the merits judge, while all the information would be made public before the merits judge? That he is concerned about would not be. I was thinking hypothetically of a situation where an anonymous person says, for purposes of this litigation, I am willing to stipulate that, I did 1, 2, and 3. And let's suppose, in my hypothetical, those are robbing banks. All right? But that was 20 years ago. Ohio has seen fit to grant me this other way of living my life, and I've taken advantage of it. And now I'm facing a situation where there is an absolute bar with no opportunity for me to present any extenuating circumstances. And that, under this theory, is unconstitutional.
So, Your Honor, I think under the rules of the DC District Courts, plaintiff seeking a motion to file under a pseudonym files the motion and any accompanying evidence, in this case, a declaration under seal. So that information is private in the district court.
No, but I'm thinking of the average case. It can be child cruelty, and the whole record is sealed. All right, but before the district court hearing the matter, or it could be a financial situation where all of the records involving the various companies, and in antitrust cases, the financial records are all sealed. So the public doesn't know. And there are a lot of states that have laws that allow drug manufacturers, et cetera, to litigate, and we never know because the case is sealed and the drug manufacturer's name is never made public, even where there is an award against that manufacturer. So I'm trying to understand, in this context, while the district court turned down this one avenue, does your client have these other avenues, or are they simply not doable? I mean, he may not want to do them. I understand that, but I mean, they're not doable as a matter of law and procedure.
So, Your Honor, a sealing is generally considered to be a more invasive public closure than proceeding under a pseudonym.
No question about it. So you lose the whole loaf of bread. My question is, can you get half a loaf? Can you get 3/4 of a loaf?
So in this case, simply keeping certain information confidential wouldn't protect the privacy interests that Dr. Doe is interested in protecting, because his name would still be in the caption of the case, and given the nature of his claim to have standing, he would have to be someone with a felony conviction. And so—
No, but that's what I'm trying to understand about this whole procedure, because there are all kinds of rules that we have where parties are not named in the caption. All right. So I'm just trying to understand whether this is your last gasp. I'm just not clear it is.
Your Honor, I think outside of sealing the entire case, which, as I said, is a higher bar and is not something Dr. Doe wants to do. He thinks it's important for the public to be able to follow and understand this litigation. We don't believe that there is any sealing or redaction that could keep the link between Dr. Doe and these previous convictions private. And I would note that in Ray sealed case 2, there was a confidentiality order. And so part of this court's consideration was
Right.
that, right, Your Honor. So it was that there was information that could be kept out of the public record and that the public had an interest in knowing other parts of the record. That's just not possible here for the reasons I explained.
Judge Rogers, do you have any more questions?
And my only other thought, I was thinking about this, one of my colleagues suggested there are all kinds of other people who can attack the constitutionality of this statute. And I suppose for purposes of standing, you'd have to show what, that you have these convictions, they're public records. You want, nevertheless, to work for this federal agency, and they have a bar, an absolute bar. And so this law, I'm just trying to think about how this pursues if it's not done through this process. And it just has to be brought by somebody who is not seeking the full fruits of the state action when my hypothetical plaintiff is seeking to work for the federal government.
I think Your Honor is right that given the nature of the standing here, this is a particular class of potential plaintiffs who are subject to the sorts of stigmatization that I described. And Dr. Doe is in a particularly unique position here as someone who does have these pardoned and sealed past felony convictions, and so is, as FDIC has argued, subject to the bar, but who has also applied for and received a job offer from FDIC. So that positions him uniquely as a strong plaintiff, and I think demonstrates the unique privacy interests that he has here.
Any more questions?
Thank you, Your
Thank you
Honor.
very much, counsel. We'll give you some time for rebuttal. Morning.
Good morning. May it please the court. Jane Lyons from the U.S. Attorney's Office on behalf of the Federal Deposit Insurance Corporation and a director named Jonathan McKernan. After reviewing the evidence the plaintiff put in the record to attempt to meet the weighty burden this court has set for proceeding in a civil action under a pseudonym, the district court found that the plaintiff did not satisfy his burden under the applicable test. The district court's conclusion is a reasonable one. Within its discretion, in light of the requirement that parties be identified and a strong presumption favoring public access to judicial proceedings, particularly in cases brought against the government. In the context of claims challenging the constitutionality of a statute prohibiting the FDIC from employing convicted felons, neither the status of the conviction under Ohio law nor the level of obscurity Doe has achieved for the conviction in the internet age are dispositive or worthy of what this court called a rare dispensation in Ray sealed case, the 2020.
So I was going to ask you, is it your view that in this age in which we live, there is no such thing as privacy?
No, Your Honor, there is still a zone of privacy.
No, but somebody who wants to find out about me can just keep digging, regardless of all the court orders that may be out there that say I can proceed with litigation using a pseudonym.
It is certainly more difficult to keep something as public as a felony conviction a secret for decades, the way that Dr. Doe has
Now, this is a
selectively.
state. these are state convictions, right?
Yes, Your Honor. Ohio
So
State.
the federal government is saying the states, the sovereign states, have no authority to erase their records in effect. And
No,
I'm just trying to understand that the federal interest is quite different from, or it's certainly separate from the state interest.
I think that's the best way to put it. It's a
right.
separate interest. And maybe, well, the best place to start in thinking about this is that, as this court recognized in the In Re sealed case from 2020, that the doors are open as the starting point, and we generally require parties to a lawsuit to identify themselves to protect the public's legitimate interest in knowing all the facts involved, including the identities of the party. And that
So
goes back to,
hypothetically, suppose I have the dispensation by Ohio, so that I don't have to tell you about my Ohio convictions. But under the district court's order and our opinions, the only thing I could do would be to change my name.
no, Your Honor, but you would have to consider whether your paramount objective was to keep that conviction secret or to try to obtain a benefit, notwithstanding it. And that's really what this case is about. The first factor that the court has spent discussing this morning of the test has two buckets. And the district court ruled Dr. Doe out of the first bucket, which sort of just leaves him by default in the second bucket. And the first bucket is for things that commonly involve issues such as sexual activities, reproductive rights, bodily autonomy, medical conditions, and the identity of abused minors. Nothing in the record suggests anything remotely in those
Well,
areas.
you have an adverb in your sentence, commonly, not exclusively.
I respect that, Your Honor. This test is meant to not check boxes. It's meant to be applied contextually. But in that context, it is important to recognize that the public has a right to understand this litigation, and everyone with assets in a bank has interest in maintaining the integrity of the FDIC's workforce. The FDIC is an insurer of public bank deposits. It acts as a receiver for failed banks, and it is a regulator for banks. These vital roles in the operation of the statute that was enacted by Congress, as has been recognized this morning and signed by a president, and the vital roles in the operation of that statute should render the public interest in this case high. And I recognize that Doe has some privacy interests, but they are not of the nature required under Factor 1 to be recognized as needing secrecy. I would also note, in response to my friend on the other side, that he has also brought a related proceeding, which is what it's called, a related proceeding, not claiming to have done that in a Doe capacity. He's challenged the agency. So this is a selective secrecy that he is employing. In terms of
This other proceeding, he's brought another proceeding in his own name that reveals the fact that he has a felony conviction?
yes, it's an administrative proceeding, but that unleashes
Did you flag that in your brief?
his control.
Is that in your brief?
It's in their brief.
There, okay. I'm not remembering this.
I can't tell you right off this second whether it's in mine.
That administrative proceeding is a public proceeding in which he reveals that he has a felony conviction in his own name?
It's not a particularly public in the sense that it's an administrative proceeding, but an administrative proceeding
Administrative proceedings were public.
they are, but they're rarely attended by the public.
I don't.
Is that the sort of administrative proceeding that, from which he could seek judicial review?
I'm not sure about that, but I am also not sure whether it could result in a published decision by a decision maker that is something that, say, you could obtain under the Freedom of Information Act. And let's talk about that, because those are the cases to establish the privacy interest that my friend on the other side is relying on. The FOIA cases are a really different context that's being assessed for purposes of privacy interest, because the interests in the FOIA that are being vindicated are what the government is up to. not what the plaintiff has been or was ever up to. So I think those cases are inapposite. Rule 10 of the Federal Rules of Civil Procedure is about what the plaintiff is up to and who is bringing the challenge. And here, where it's a challenge to a statute that has been on the books since 1950, it's important that the public have insight into who is trying to make an exception to this statute. The FDIC also can't hire people who've been through bankruptcy proceedings, and there are other agencies that have the felony bar in place as well. The FBI jumps to mind.
I jump to your prong 4, which they say is sort of a heads you win, tails the plaintiff lose factor. Explain to me your understanding of that factor in light of our precedent.
Okay, so I think the first thing to straighten out is that my friend on the other side has said that the district court didn't understand this factor and got the law wrong. And that is incorrect. District court clearly states on appendix page 35, he acknowledges that that anonymous litigation is more acceptable when the defendant is a government body. And that recognizes that the government doesn't have the same kind of privacy interests that individuals have. So he recognized the law correctly, but he found that principle was superseded by the very heightened public interest here because the plaintiff seeks to challenge the operation of a law that will impact not only the plaintiff, but also other parties going forward.
Isn't that true for every lawsuit against the government?
No, Your Honor. So let's take a typical employment discrimination case with a single plaintiff who's seeking relief, back pay, reinstatement, whatever. That only impacts the plaintiff. The resolution of the case by this court, one way or another.
If there's any legal questions resolved in that case, that's going to affect people in the future.
Yes.
There aren't a whole lot of cases that get maybe this is an appeals court perspective, so maybe that's my problem. They come by that don't have some legal questions resolved in the process. And we're, to the extent there's sort of I hate to use the phrase, but common law that's built up around factual determinations to sort of create what facts are enough to survive summary judgment, which ones aren't in each particular case. That may seem individualized, but that builds sort of a body of law as to what it takes, for example, to avoid summary judgment. So it's hard to figure out what cases, particularly against a defendant like the government, do not affect other parties going forward.
I think it's just more direct in this kind of a challenge, a constitutional challenge to the.
This may be more in your face, but for purposes of your analysis of what the district court did here and your arguments in your brief about factor 4, it seems to me that you want a position under which if it's against a private defendant, that weighs against pseudonymity. And if it's against the government, that weighs against pseudonymity. Is that your reading of factor 4?
My reading of factor 4 depends on the context in which the entire analysis is taking place. And the factor 4.
Our analysis, I want an analysis of factor 4. I recognize that there could be other factors that might weigh in favor of pseudonymity, but I'm concerned about your reading, the government's proposed reading of factor 4 in this case.
To the extent that the government's brief is not as clear as it perhaps should be about the application of factor 4, what is at issue this morning is the district court's application of factor 4, which I think is correct.
So you're disavowing any broader reading in your own brief, any broader argument in your own brief?
Yes, I did not mean to broaden the factor 4 analysis at all.
But if it gets to whether the decision in the matter is going to have implications, and one doesn't know it, whether to allow someone to proceed under a pseudonym is decided right up front at the beginning of litigation. So it's a little hard to predict whether it's going to be a fact-specific case or it's going to have some legal issues that could affect people going forward. So I'm just not sure how yours, or as you're describing the district court's reading of factor 4 even works at the beginning stages of a case. You just can't tell from a complaint if there's going to be some important legal question that's going to be raised.
Well, I think the general, also constitutional requirement that the courts limit their exercise of jurisdiction to concrete controversies is part of this.
I'm not making a standing argument here. I'm saying that you decide pseudonym stage at the beginning of a case before there's an answer, before there's a 12b6 motion.
Yes.
And a complaint asserts claims. It
Yes.
doesn't always say, by the way, here's a big gnarly legal issue that y'all are going to have to resolve in the course of deciding my case. That's not always known.
That's true, but it's not
So
always,
you can't apply the test as you propose as to determine whether the decision is going to have implications for other parties. You can't do that
we,
at the front end.
The district-
Always, or maybe not even commonly.
the chief judge is tasked with doing the best he can at the outset of the case in applying this test, and the parties are free to continue litigating it if Doe status is granted. There are opportunities farther into the litigation for another party to move to strike the Doe status and unmask, for lack of a better term.
But it's law of the
The
case of the
plaintiff.
parties.
It's a law of the case, I suppose, at that point. I've just seen cases where it is litigated later, or as Judge Rogers correctly pointed out, it becomes enmeshed with the similar analysis under the Hubbard factors for whether to seal parts of the record to correctly achieve the outcome of giving the public enough information about what the litigation is about and vindicating those important and compelling interests in open judicial proceedings.
Would the privacy interest be any different in this case if he had been acquitted or investigated but not charged?
If he had been investigated but not charged, I would say yes, the privacy interests would be different because one of the district court's main reasons
Why would acquitted not be even?
might be even stronger. I'm just taking these one at a time as my brain reacts. If he were acquitted, I don't know. Now, if he's acquitted, he's not subject to this bar. So
Well,
this case isn't happening in this
far,
case.
But one could imagine some other challenge where he doesn't want to reveal the fact. Have you ever been arrested?
Right. But
Have you ever been the subject of a criminal proceeding? Questions can get phrased differently by employers on applications.
sure. And it's important to recognize, I think, that an employer or the federal government doing a background investigation is doing a different process than an open judicial proceeding in court. Those are just really different
I'm
contexts.
just asking you for the nature of the privacy interests. You think it'd be a heightened privacy interest if they were acquitted or investigated but not charged?
Yes, those would be higher privacy interests
Doesn't
than
Ohio
talked
law
about.
effectively make his prior record the equivalent of a acquitted or not charged? It's as if the criminal prosecution never happened.
I don't think that the federal government is bound by, in terms of not asking the more specific questions about, have you
I'm
ever,
asking for purposes of the privacy interest at stake,
yes.
whether the question right now is just whether there's enough privacy interest to proceed under a pseudonym, not the merits of the case. The FDIC is interested in knowing this. It is only whether he should proceed under pseudonym. And if the interest in privacy that he has is equivalent to that of someone who's acquitted or investigated but not charged, then I'm not sure why you're discounting his privacy interest.
This test has not really ever been articulated, at least up to now, in terms of the magnitude of the privacy interest. It's really the nature of the privacy interest.
I'm not saying magnitude or, I don't know what your difference is between magnitude or nature. If it's parallel to, if it's tantamount to being acquitted or charged but not prosecuted, charges dropped, then how is this any different for purposes of the nature of his privacy interest?
Well, you would have to assess the nature of that privacy interest in the context of the legal challenge brought, which would be perhaps unrelated to the criminal activity.
Again,
Or
I'm
charge.
asking you for these cases, you were saying up front that you didn't think he didn't fit in the first bucket. And my understanding from your brief is you don't think that he carries a lot of weight in whatever you think the second bucket is under the first test. And I'm asking you why it's not a heightened and reasonable privacy interest to recognize if we would do the same for someone having been acquitted.
All I'm saying, let me see if I can attack this a different way and say it better. All I'm saying is that the district court reasonably found that the privacy interest that's being asserted in this case is not one of the ones that's been recognized to favor Dr. Doe with regard to
So far, but
factor
it's
one.
not an exhaustive list.
No, it's
And if we
not.
would, and if we would recognize a privacy interest in acquittal, well, you were acquitted, you just shouldn't have this fact that you were arrested, investigated, hanging around your neck. Then why is this different? Or do you agree that it's at the same level since it was sealed? Or in a case where it's expunged? They have different words for it in Ohio.
Yeah, Ohio law seems a little
Yes,
complicated.
it is, but why are these not on a parallel
Well,
level?
I think if an employer in Ohio could have asked Dr. Doe about his conviction when the FDIC was considering the matter, I think that's a good indicator that it's not such a private matter that it would rise to the level that you're talking about for an acquittal. Also, all of these challenges and issues have to be addressed in the context of each case, and that's what the district court does, with a mine run of cases, and it decides which of them are warrant and meet the weighty burden. I'm not convinced that it's impossible for Dr. Doe to meet the weighty burden, but I think the important point here is that he didn't on this record.
Do you have any questions for my colleagues?
No, thanks.
All right, thank you very much, guys. Sorry, did you want to do a one-sentence wrap-up or something?
Please affirm.
Okay.
Thank you.
All right. Ms. Lichtenstein, we'll give you 2 minutes.
Thank you, Your Honor.
Say your name
Just
right, Lichtenstein?
uh, Lichtenstein.
I apologize, Lichtenstein.
No, not a
I
problem.
didn't retain it in my head. I apologize.
Not a problem. Just a few quick points, Your Honors. First, the related proceeding that was mentioned by my colleague was in fact not public, and Dr. Doe, as we mentioned in our briefing, filed a motion to seal that proceeding. But more
Is
importantly,
that motion granted?
I believe it's still pending, Your Honor.
So as of now, what is this proceeding?
It's an EEOC proceeding, Your
Okay.
Honor.
Is that a public record proceeding?
My understanding is that those are presumptively private.
Presumptively private? Okay, and so they couldn't be obtained through FOIA or anything?
I don't believe they could be obtained through FOIA, but I know that they are not accessible to an average person just searching the internet.
What about an unaverage person? I'm not sure what you mean by.
So
I
I think
searching the internet, that's.
that gets to my point, which is that the broader point here is the relevant fact is not whether anyone in the entire world might know this information about Dr. Doe, but whether the general public knows it, whether it's accessible to someone just searching his name. And that is the difference between any potential, revelation to an employer or someone else who's an individual, rather than having his name be linked to this information in an irreversible way as part of this litigation. The second point I just want to make is that this court has recognized in MetLife that the background confidentiality regime of the state law is important to its evaluation of the strength of the privacy interest. And the district court failed to weigh that interest at all. It failed to acknowledge the background confidentiality regime set by Ohio, in which the court determined that Doe's private interest outweighed the public's interest. It failed to acknowledge this court and the Supreme Court's precedents in finding that there's criminal history information that is private and presumptively sensitive.
You're suggesting that federal courts, in answering this procedural question, have to credit or follow state law?
Not at all, Your Honor. They're not bound in any way by Ohio's law, but this court has held that it's an important factor in assessing the background confidentiality regime because it's a determination by Ohio that Dr. Doe's privacy interests here outweigh any possible public
Even if
interest.
Ohio, I don't know one way or the other, but imagine you have a state that is a real outlier and treats something with a heightened level of privacy that no other state accords any relevant level of privacy to. Would a court still have to?
I think this court could take into account that it's an outlier, but there are comity interests in recognizing the sensitivity with which Ohio has treated this
The public that
information.
the federal courts serve is the entire country, not a single state.
Absolutely.
So if there's no broad privacy interest, it's recognized. That's why I was trying to get to with my sort of objective or individualized inquiry as to how private something is kept. The types of categories we've recognized before have been things that are sort of broadly by society recognized as very, very private and intimate forms of information. And felony convictions just don't seem to fit that category.
I think courts have recognized that criminal history information is exactly that sort of information. Courts have referred to an opprobrium approaching the opprobrium with which society treats criminal information and crediting other privacy concerns. But what I think is also important here is that the district court failed to consider any of this at all, and that was its abuse of discretion. It didn't discount the Ohio confidentiality background. It didn't merely discount Dr. Doe's privacy interest in his pardoned and sealed convictions. It simply failed to address them. And as the Fourth Circuit has recognized in Doe v. Sidar, a failure to account for the nature and strength of a plaintiff's privacy interest is an abuse of discretion.
Just one more clarification. Is your argument that the privacy interest here is in felony convictions, or is it only in sealed felony convictions?
Your Honor, our argument here kind of weaves all of these threads together. Dr. Doe has a privacy interest in criminal history information that has been pardoned, that has been sealed, and therefore which is considered no longer to have occurred, and that has faded from the public view. So all of those factors together are what give him the particularly heightened privacy interest in this information, and that's unique to the circumstances of this case.
Colleagues have no further questions?
Thank you. We urge the court to reverse and allow Dr. Doe to proceed under a pseudonym.
Thank you very much. The case is submitted.
Case number 24-5011. Michael Hill, President et al., appellants versus United States Department of the Interior et al. Ms. Seilstad for the appellants, Ms. Sprague for the appellees.
Good morning, counsel. Is it Seilstad? Is that?
Seilstad, yes.
Okay, sure. I heard
Thank
right.
you.
Thank you.
Good morning, Your Honors. My name is Andrea Seilstad. I represent the appellants, Michael Hill, who is present in the courtroom today, the Apsolica Allottees Alliance, and other named individual allotment landowners who are also members of the Crow tribe. I would like to reserve 4 minutes for rebuttal. The appellants are challenging the Department of Interior's failed implementation of a compact approved by the state of Montana, the Crow tribe, and the United States that sought to resolve litigation over between the three governmental entities. The individual allottees were not parties to the compact, but are affected deeply by its terms and its implementation. Under the terms of the compact, the United States agreed to waive the allottees' Winters Doctrine water rights and place them within a collective tribal water right. Under the Act's sections 410B and E of the Settlement Act, the waivers were to take effect and the terms of the compact become enforceable upon the Secretary of Interior's publication of a statement of findings. And that took place on June 22nd, 2016.
Ms. Lustig, could you, one of the things I wasn't sure going through the briefing and the record is why the Winters rights of these allottees are more valuable than the rights that are afforded under the Act. Given that Winters rights would have to be adjudicated and, in a lengthy process, the Act seems to protect, to give people the same rights that they have or greater. So if you could just explain that to me. I mean, obviously, there's some sense in which these winter's rights are understood to be more valuable.
Yes, well, I mean, going to the definition of the winter's rights, they are a paramount right that goes back in priority to the date of the reservation's creation under the treaty, which is May 7th, 1868, which is critically important in times of shortage. There's other rights that go along with it in terms of rights that they can be expanded, they can't be forfeited due to lack of use or abandonment, as can equivalent state law rights and the like. So there's many different parameters that come along with that.
And
The
those-
problem
and
with the
those parameters do not come along with the
Correct,
rights.
correct. So under the terms of the compact and put into place with the legislation, the water is taken, waived by the United States government who represented the allottees without their participation or consent. The United States agreed to sign waivers of the individual allottees' Winters Doctrine water rights, which would be triggered upon that enforceability date. And then the water of the allottees went into this collective amount of water that also was shared by the tribe and by other allottees. And the way of accessing it, this is also critically important in terms of the impacts. The way of accessing that under the terms of the compact and the act was to apply for a permit, which is a defeasible permit, which could be taken away or even argued about as to whether they were going to get this defeasible permit. And most significantly, which underlines our claims also, the permit was to be obtained through details of a tribal water code, which would set out the parameters for application, qualifications, and the like, and also a dispute resolution mechanism if it was denied. And that tribal water code to date has yet been approved by the secretary. So there's really no way for them to get their water rights. But even if there was a perfect implementation by Department of Interior, there's still an extinguishment of the actual right, followed by the possibility of applying for a permit. There's some other details in the,
No, that's.
it's very complicated
No, no,
and this will be one of the things, but there's
sufficient.
some other details.
This is, I mean, we are decade plus past the compact and approaching a decade since the statement of findings. Something must be done to be allocating water rights in the meantime. I mean, the secretary is supposed to do that until there's a water code, right? So folks are getting water rights, have been getting water rights.
Well, factually, and this would be something I wanted to emphasize, that we're at the pleading stage and the case has been dismissed, so not all of these facts have been developed, and we would suggest that the district court erred in that, and we should be remanding it to develop the factual record. But through the Montana Water Court adjudication, the state water right holders effectively had their water rights, their claims submitted and adjudicated. Several thousand of them with a precise amount of water that can be obtained and distributed. The tribal water users, it's not correct, we understand factually, that they are able to get all their water. I mean, if somebody had water that happened to be flowing across their allotment, they might be able to get it. But if they needed it to be brought to them through the irrigation system or other means, it's quite likely that they wouldn't be able to do it. And furthermore, in the course of the Montana Water Court adjudications, which are one of the things that the Department of Interior was supposed to ensure happened before it published the statement of findings, there was never a point where the individual allottee's water right was submitted according to the detail that was supposed to be provided to give an individual recognition of it. The current use list was never prepared. So the non-Indian state law water rights holders have defined rights that were adjudicated. And the pro allottees do not have those equivalent rights defined. So many of them are not able to actually get the water. And they're not even able to figure out how they would go about applying for it. And so they are only able to get it if something was already flowing upon their land that was already working.
Ms. Sosna, can I ask you about, so one of your arguments is that the tribal chairman did not have the authority to extend the deadline for the statement of findings.
Yes.
And so I've looked at the Crow Constitution and the other sources of law that have been cited, and it seems that the tribal chairman under the Constitution has all the sort of authorities we would associate with an executive. You know, the tribal chairman can implement the law, can negotiate with other governments. And so I'm wondering why those constitutional authorities don't include something as sort of ministerial as this, you know, agreeing to moving the deadline. I'm wondering if there are any other sources of law that you can cite to. I mean, of course, I'm not an expert in the law of, you know, the Crow tribe, but I'm wondering if there are any other sources of law that you would point to that would limit the tribal chairman's authority.
Well, I might push back a little bit on the idea that the extension was simply ministerial, but I do see your point that there has to be an ability for a tribe or any entity to kind of take some kinds of executive actions to take care of things. The question is which things are important to involve the larger decision-making authority of the sovereign entity and which things are purely ministerial. In this case, the extension, because the deadline was so significant of a triggering point, and by then, as I think you have pointed out, lots of years had passed since even to the point of June 22nd, 2016. Many things were not in place by then. The current use list had not been created. The water hadn't been quantified with respect to
that doesn't go to the authority of the chairman.
Okay, well, okay, so going specifically to the authority, I would say, I mean, we cited in the brief to the federal authority that requires Interior to know and to defer to the authority of the tribe. Part of that is to approve to know and to the constitutions of the tribe. The Secretary of Interior actually approved and reviewed the Constitution of the Crow tribe. If you look at, I mean, that's really the Constitution of the Crow tribe would be the primary starting point.
So I mean, reading that just from the way I understand, you know, constitutional authorities and executive power, it would seem that the tribal chairman has this authority.
Well, first of all, it's the tribal chairman himself has much more limited authority. The part about negotiating for things like mineral rights or water or things like that is delegated to the executive branch to be involved in the negotiation. That part is true. There's four government officials that comprise the executive branch. We didn't emphasize that point in the briefs, but that's another point, that it's not just the tribal chairman that's making the executive decisions. It's a group of 4 other people. And in this case, there was only one that came forward. The second part is, if you look at the authority of the Legislative Council in that same document, it's quite clearly laid out as needing to approve the negotiations of the executive branch, which in issues of this nature. And then the third goes to the ratification by the General Council. Many tribes do have a more consensus-based form of governance that akin to referendums, but the whole community comes together of matters of importance. And this tribe found the issue of the water compact and the water rights to be of paramount importance. So the other documents that show that and really help interpret the Constitution itself are some of the documents that we submitted for that the tribal legislature passed, either by resolution or by...
Resolution, I mean, from what I can tell, you know, looking online and how tribal resolutions are treated under the Crow Constitution, I mean, they're basically just like what we would think of as like a sense of the Congress. They're not binding legal commitments. Are resolutions binding law under the Crow Constitution?
Well, the interesting thing, the resolution you're talking about, that 1207 from May 24th, 2012, protesting an earlier decision by the chairman. The thing that's significant about that is it summarizes, it's an interpretation really, and a good detailed summary of the law of the tribe.
The law, is it? I mean, a resolution is not like a statute or binding on anybody. Is it?
It's not the law and the same thing as a constitution or like the election code, something like that. Like the ratification vote procedure is modifying the election code. So that is at a level of a law or an amendment to a law.
Right, so
The resolution is
different.
different. That's true. But the thing that's significant is it's putting the department, okay, so that what informs Department of Interior about what any tribe's laws are? They have to figure it out and look at the tribal governing documents that are there. I mean, with all due respect, I think that the Constitution is quite clear on this point. But if it wasn't clear, the resolution reminds Interior, no, this is serious. You have to pay attention to these things. The tribal chairman does not have this authority. So in case there was any doubt, it puts them on notice of the importance of following these provisions of the tribal constitution. And in the last sentence, I mean, one of the sentences, the Crow Tribe Legislature further gives notice that absolutely no waivers or releases of Crow tribal rights and claims shall be considered unless proposed settlement terms are fully reviewed and deliberated by the Crow Legislature and the Crow Tribal General Council. So it is an interpretive issue. It does probably, I'm not sure that it needs to be resolved at the level of appeal, like exactly which branch had the proper governing authority, but I think there's significant, the allegation in the complaint, which is what we go by, is that the tribal chairman lacked authority as one person to do that the tribe had been trying to, through its legislature and its exercise of its resolution power, to bring this to the attention of Interior. Also, if you look at the Settlement Act itself, it's quite clear it needed a full referendum vote to start the whole process going. It had to be certified. A better interpretation is that when there was going to be a change, that was also significant, that the United States needed to look to the tribal governing processes. So going to just a word about the pleading standards, because that's like the fundamental issue. There's lots of things alleged. There was a very detailed complaint that was submitted. The notice pleading standard is what we go by. The things I would point out would be that we look at the factual allegations. We don't have to match each fact to each element of the legal claim. And we have established through a very detailed complaint the provisions for claims under the Administrative Procedure Act, as well as for breach of trust and the 3 different constitutional claims.
So I understand that had there not been an agreement to an extension, so if there had been no extension and the statement of findings were not filed, the statute says then the statute goes away, and
Yes.
I guess the compact would necessarily go away too, because it wouldn't be ratified by the United States. But what is your authority that if an extension were, say, assume for purposes of this question, mistakenly granted, but there was an extension agreement by the chairman, and the government went forward and then filed the findings on the extended date consistent with the statute? What is the best authority that because it was mistaken, we go back and the same consequence happens? That is, that the statute ceases to exist, the compact ceases to exist, as opposed to good faith mistake, but the statement of findings are there, the trigger point is there, things have gone into motion. What is, and this is a sort of legal question that we.
Yeah, I think that
12B6.
I think the best authority for that, what happens in the event you don't reach the ending or you made a mistake in the approval process of an extension, is in the act itself. The act itself, well, first of all, if you look at the legislative history of the act,
Tell me where the act itself says what to do.
well, the main thing is, and the act provides exit ramps. The act wanted these things to be done in order for the allottees to get the best recognition of their water rights and put it on Interior to do these series of steps. And it recognized that there are a few things that were essential to be done And then if they couldn't be done,
Right, those
There's-
seven
that
things were
goes-
done. It said what those seven things were, and there's no
Yes.
dispute that those were done. And that those were done at the time the statement prior to, and so completed by the time the statement of findings of fact were done. So the things that Congress wanted done were done. They were done by the time the statement of findings of fact was filed. And so where is there indication that not even so, because the extension was perhaps mistakenly agreed to, as your argument, let's assume it's true for these purposes, was mistakenly agreed to by the chairman, that now, after the fact, everything falls apart.
well, it had, those 7 steps, plus the development of the tribal water code, we would posit.
Congress did not say, we do not want the statement of findings filed until there's a water code. It just didn't say that in the statute.
Well, it did say that the water code had to be completed within 3 years of the
It did,
act.
but we have,
So-
those are separate legal claims when someone is untimely in their actions under a statute. They don't make the whole statutory scheme evaporate the way Congress said would happen if the findings weren't filed absent an extension.
Okay, 2 things about the 7 steps. The 7 steps, the water court adjudication was completed by the
Mhm.
Montana Water Court.
Mhm.
We alleged, and we would emphasize that the rights of the individual Crow allottees were not
Right.
adjudicated.
some
So that
reason-
wasn't completed actually with respect to the Crow individual water rights. With respect to your question about, well, let's say everything was done perfectly, I still push back on the tribal water code and whether that needs to be completed by that time frame. But let's posit, as you suggested, that everything was completed and the only thing wrong was this 3-month extension
Mhm.
and how that came about. The timing, I guess I refer you to that section 415 that talks about the automatic repeal, that Congress, when this statute wasn't so written in stone that it's just going to go forward come hell or high water. There was going to be a number of things that had to go into place to make it work. Some of them were the funding issues about the projects, and some of them were about the identification, the quantification of these water rights. And there was a period of time, a rather extensive period of time, in which these things could be done. And in the statute, there's 3 places that allow for a kind of like we called it a fail-safe provision or an exit ramp if they weren't done. Some of it had to do with the financing for the Water Act, which there's no guarantee of what's going to happen with that. But with respect to
The funds were made available as promised at the time the statement findings was made.
yes, but not all of the funds have been appropriated yet. They have there's that 2030 date that is in the act that would be another triggering point for nullifying the terms of the act and the waivers as well. So when you look at the legislative history that was presented to Congress, they were from the administration, there was high concern about the ability to quantify all those water rights and do all the steps that needed to be done to protect the water rights. Actually, the Department of Interior officials weighed in on that and actually asked that Congress delay the passing of the act. Well, Congress didn't delay it. They put the burdens on Interior, and then they did put these exit ramps in the statute. So 415 is one of them. So it's pretty clear Congress wanted things to be done correctly, and they needed to be done correctly. Otherwise, we end up where we are now with an act where, as we've alleged, even with our equal protection claims, state water users have their rights happily adjudicated and can do what they want with them. They can sell their land knowing what they are, and tribal members allotment owners can't do that. That's certainly not what Congress wanted leading into it. And the solution for Congress is to provide that automatic repeal if things couldn't be done. And so we posit that the statement of findings should be set aside under the Administrative Procedure Act, and then the automatic repeal would be in place.
My colleagues have any questions?
Yeah.
Thank you very much, Council. We'll
Thank
give you a
you.
couple of minutes for rebuttal.
May it please the court, I'm Mary Gabrielle Sprague, representing the Department of the Interior. The allottees allege failures of implementation. If those are correct, they may well have claims to address those specific failures of implementation. But that is not what this lawsuit is about. This is not what their claims target. The linchpin is trying to leverage the statement of findings to invalidate the entire statute. They believe Congress made a bad deal. They wanted a different deal. But the Section 415, which calls for automatic repeal, simply does not go into effect in this situation because, as Judge pointed out, all 7 of those tasks have been completed. As to
you talk about this extension decision as sort of ministerial, and that's often how
the publication of the statement of findings was ministerial. The extension agreement, Your Honor, we think is entitled to an abuse of discretion standard, but it did require discretion in deciding whether to enter into it. And our position on that is there has been no abuse of discretion.
Ministerial, it hinged on this extension. I'm not sure whose discretion abuses. I don't even know what your abuse of discretion argument is as to agreeing to the extension. Your decision, the Secretary's decision?
The Secretary's decision. I mean, it's the Secretary's.
The statute says you got to have the agreement of the tribe.
Correct.
Full stop. You have to have the agreement of the tribe.
Right, and it does not define who the tribe is in this circumstance. The Settlement Act requires.
So the Secretary had to act reasonably.
Correct.
Okay, well, that's not an abuse of discretion standard. It's a reasonableness standard. But I want to get back to, even if the ultimate finding itself, filing of the statement of findings was ministerial, it was when it would be filed was hinged upon this agreement to an extension. And it seems to me the argument about who could make this decision to extend the time, ordinarily it seems like something that's administrative, but in this case, the type of thing that an executive could do when I say administrative. But in this case, the decision whether to extend the time, to agree to an extension of time or not, was really a decision whether to go forward with this compact or let it die on the vine. Because if they didn't agree to the extension, that's it. The Settlement Act's gone.
Right.
The agreement's gone. That's a very substantive decision about whether to go forward with the agreement or not, which seems to be something the Constitution puts squarely in the legislative branch.
Yeah, Your Honor, we disagree with that. I mean, the reason, it's not even clear that an extension was required. Out of an abundance of caution, the chair.
Extended upon agreement by the tribe to a later date, and
Correct.
you filed at the later date. So you had to have
Correct.
the tribe's agreement.
The uncertainty was that the allottees had challenged the judgment of the Montana Water Court. It was affirmed in the Montana Supreme Court in July of 2015. They then petitioned for certiorari in the United States.
I understand.
Right, and that petition was pending as of March 31st, 2016. So as they were approaching that deadline, there was a concern that the pending of the petition challenging the Montana Water Court judgment could mean that the judgment was not final, which is the first task that they needed to complete. So the chair and the secretary decided.
The statute says if the secretary does not publish a statement of findings no later than March 31, 2016, or extended, so it could be extended, but extension, if you needed to go after that, whatever the reason, I'm not saying you had a bad reason, whatever the reason, you had to go forward to a later date for extension. It had to be agreed to by the tribe and the secretary.
Correct.
Secretary agreed, obviously, for the extension.
Right. And
The tribe had to agree. Now, the question is whether there was a reasonable belief that the chairman could agree to that.
Yes, and there.
I'm going to finish my sentence.
Sorry.
Please. All right. And if you look at it as well, it's just an extension of time. We all like that. It seems like something within the executive branch. But if you look at the statute, which attaches extraordinary consequences to the agreement to agree to an extension or not. That is, it is an off-ramp from the whole agreement. Will we have the agreement or not? Will we have the agreement or not? Will we continue with this agreement or not? Because it's not working for us. That's a decision that the council or legislature had to make, and is not an executive decision. So this statute attaches such significance to this agreement to an extension. Then how could the secretary reasonably think that the chair alone could decide that when it really is a judgment about whether we still want to have this agreement or not?
Because, Your Honor, the Settlement Act provides for a general council vote only for the initial ratification of the compact, which happened in 2011. As of then, the tribe, as the full tribe, had voted to support this
I understand that,
settlement.
but now the question is whether as a matter of tribal law, not the Settlement Act, who has the authority to decide whether to extend the time period? And if extending the time period is actually a judgment about, do we want to go forward with this compact given where we are in 2016? That would be a legislative decision, not an executive one.
But, Your Honor, I think, I believe it's an executive. It was reasonable to conclude it was an executive branch decision here because the Constitution does afford to the tribal chairman the ordinary scope of executive duties. And
But this is
here,
not ordinary. This is essentially the extension judge. It's difficult because we don't think of extensions as having these types of consequences. But if you think of the extension judgment as, do we want to go forward with this compact or not?
right,
Do
and
we want to unsign or stick with it?
but there was
And
no
that would be a
indication.
legislative judgment.
There was no indication from the legislature or the general council as a whole that they wanted to repudiate the settlement. There was a,
You didn't ask them. That's why they were.
Your Honor, the general council
gets to weigh in.
under the Constitution meets biannually. You can trigger the extraordinary procedures for initiative or referendum. Those procedures take time. There was not even any thought that there was a need for an extension until the Alatis filed their petition for certiorari. The legislative
Did they
branch
file it-
each is
What date did they file that petition?
in December
Okay, so you had
2015.
7 months. Or 5 months, I guess. tomorrow.
3. I mean, March 31 was the deadline.
Okay, so just, yeah, you're right, sorry.
So the undertaking of trying to, just as a practical matter, apprise
You said the council didn't ordinarily meet between December and March. You said they meet.
the general council typically meets every
Yes.
2 years.
Mhm.
The legislature meets quarterly under Article 4, I believe. The
with
second
the
week in January, April.
There's a meeting in January.
You're right. And
Okay,
it
so
was,
we couldn't.
it was
say
not
December.
presented to them at that meeting. I would point
Well,
out
that's,
that it was,
I'm sorry. You started with we couldn't get feedback from them, but of course, they met in January. And we knew that a cert petition had been filed by then, and the federal government's fully aware of the life cycle of a cert petition and how long it takes. And it presumably knew how long it would take for the U.S. to respond to that cert petition. And so you had an opportunity to go to the legislative branch. If we look at this extension decision as we continue to agree or not with this compact, we look at it as a substantive decision, which the statute seems to imbue it with.
there was no reason to believe that the tribe as a whole wanted to repudiate the
Question is,
settlement.
who's supposed to, that's what their answer, it's not anticipating what their answer is. The question is, who do you ask for the extension? And you had the opportunity to ask the legislature. And the nature of this very unusual extension decision is so substantive and goes to the merits, the heart of whether they wish to go forward with this agreement.
Right. And
You didn't ask.
And
Yeah.
since then, there has been no indication that the tribe had a problem
That's not
with the
relevant.
extension.
My
They have
question.
met repeatedly
My question is,
afterwards.
who decides about the extension? They
And-
might have said yes. My question is not asking you guess what the legislature would have said if you'd asked them. My question is, who gets to decide to agree to the extension or not? Whether it's an executive judgment, just implementing a law, or whether it's a decision about what the law governing us is going to be. And given that Congress put this exploding provision into the Settlement Act, it was very much a decision about whether we're going to go forward with this agreement or not, given the state of things. And so you could have asked the legislature, you didn't. You asked the wrong person.
It was reasonable, Your Honor, for the secretary to enter into this agreement with the tribal
What was reasonable
chairman.
about that, given the nature of what the decision was?
Because there is reason to believe in the Constitution and the way the executive branch operates in the Crow tribe as it, with the ordinary executive functions, that was a reasonable procedure to enter into that agreement.
You're saying it's reasonable, but if it's not viewed as at all as just implementing the law, but deciding what the law will be, which is not the chair's decision, then it's not reasonable.
But Your Honor, taking the flip side of it, if they couldn't, I mean, you assume that it all could have been presented to the legislature. I don't know whether it could have been
Then
by the
maybe it's not
second
You're the
week
one that
in.
I don't have the burden of showing reasonableness here, you do. All right? And you've made no argument whatsoever in the briefs that it was unreasonable to do so, given that the legislature met in January. You've given you can make stuff up now, but there's nothing in the record that shows that this was a reasonable judgment not to take this question to the legislature.
Right. And Your Honor, the only point that the allottees rely on is the resolution in 2012, which was a protest, which did not even rescind the waivers that had been signed in 2012, and did not say that the other agreements under the Settlement Act.
This was a decision for the legislature. And this, I'm telling you, when I look at the settlement agreement, this exploding device in the middle of the statute makes the extension agreement very different than an extension agreement.
That was intended to hold everyone's feet to the fire, but there is no
And if
indication.
they don't comply with the timelines, the tribe can get out of it. The tribe can say, we don't want to go forward if you don't meet the timelines for the very reasons that have been argued to us today.
But the tribe, the tasks that were the tribe's responsibility, they did complete. It was on track. And the tribe that had voted all together in 2011, there was no indication that they did not want the settlement to go. They did not want the settlement to disappear. They wanted to proceed with the settlement. Again, I mean,
Ms. Sprague, I'm not sure why you've shifted to focusing on whether it was reasonable here, because isn't it a question of law whether the tribal chairman has this authority? So I'm not sure where the reasonableness. So like, you're saying it's reasonable for the secretary to think that the tribal chairman had the authority.
right.
But isn't this just a pure question of law
It's
under the Crow Constitution and other Crow laws, whether he had that authority?
so
I'm not sure where the reasonableness is.
the secretary has the duty to maintain a government-to-government relationship with 574 tribes, which have very different governance structures. And it's the policy of the United States, the tribal self-determination policy, to abide by tribal law wherever possible. But federal law controls, and federal law, it's a policy of federal law to defer to tribal law. And in this case, the secretary reasonably, so it is a reasonableness standard in determining whether to follow tribal law, how to follow tribal law. Her primary duty was to implement the Settlement Act that Congress had passed with the approval of the tribe, and to keep that in effect by agreeing to a modest extension. In that case, I mean, the record doesn't reveal the background story of who talked to who about precisely how to get this done. But the tribal chairman, it was reasonable for her to accept his representation that he had authority based on the Crow Constitution, and we cite various provisions. Your Honor reviewed the Constitution, for a short-term extension. If the legislature disagreed, if the general counsel disagreed, they could weigh in later. The tribal court could have disagreed if somebody timely had brought it to their attention. But the alternative was because of a possible delay caused by a cert petition that the Settlement Act that everyone had worked for decades would simply disappear. There's no indication that the Settlement Act should be interpreted to provide that result. And if there were clear tribal law, then there would be a better argument, but there's not clear tribal law. The secretary all the time in
Understand, that's why
acting
cases have
for
adopted the
tribes.
reasonableness test that we've been talking about. That's why cases have adopted it. You don't have to get it right. You have to make a reasonable determination because you can't always get it
And the
right. It's
decision was
complicated.
reasonable.
All right,
We
and then
maintain.
My colleagues have any more questions? No. Okay, you want to finish your sentence and wrap up?
Your Honor, we believe that the district court carefully reviewed the complaint, carefully reviewed the opposition to the motion to dismiss, that the thrust of the claims are that the allottees do not like the settlement. They wish there had been a different settlement. They maintain there were implementation failures. There are remedies that they likely could obtain to redress any of those implementation failures, but that they have not made out a claim that would result in the invalidation of the Settlement Act, and we ask that you affirm.
Thank you. Ms. Celentano, we'll give you 2 minutes.
Thank you, Your Honors. Obviously, you've honed in on the key issue, one of the key issues in terms of the expiration of the deadline. And we agree that it is a hard and fast legal requirement of the act that if if the publication can't be made by that March 31st, 2016, the act is automatically repealed. About the issues of the approval and the engagement of the legislature or the general counsel, there's evidence, and maybe the resolution is best put in this light. Also, the legislature was highly engaged in this and didn't like the way things were unfolded as demonstrated by that resolution. So they were highly engaged in this and inserting themselves in the process. Also, with respect to the ratification, another
They didn't do
doc.
anything in 2016.
Pardon?
They didn't do anything in 2016.
They didn't do anything in
The
2016.
legislature didn't do anything in response to the extension agreement in 2016. They met in January. I assume they met again sometime between April, May, June. So they had another opportunity after the extension agreement to react to the chairman's decision to extend time, but didn't do anything.
That may be correct. There's another point to emphasize here, however, that to the extent we're not clear about different aspects of the tribal legislative process and when they meet, because not all of this is clear. The government is mentioning times of the year that they meet, but there's also evidence that we've submitted and alleged that when it came to the water compact, they did things in a different order and they put things forward in an emergency basis in other contexts. So
Right, but then
given.
what do we take from the fact that the legislature could have proceeded or normally or in an emergency basis to respond to the extension decision by the chairman in 2016 and didn't?
Well, I would suggest that on that point, it's a different point, not within the scope of our claims. That to the extent that that would be important, it's another reason for the case to be remanded for further factual development. But based on what has been alleged, I think it's been clearly alleged, and that's what we have to go by is the factual basis that is alleged that the tribal chairman didn't have that unilateral authority. That-
Sasa, can I
yes.
just ask you a question?
Yes.
Did the allottees go to the tribal courts to get a ruling about the tribal chairman's authority? Because that would give us a
Well,
clear answer as to, I mean, did they avail themselves of the tribal courts to challenge the chairman's action? As ultra
the tribal
or-
court wouldn't have been an arena that would have jurisdiction for this kind of a decision about the interior's responsibility for
Well, it's not
implementing the
Interior's
compact.
responsibility.
But-
I mean, it would be a challenge to the tribal chairman's authority, the same way someone would come to a federal court and say, you know, the president exceeded his authority under the Constitution.
I don't know that that we've identified that there would be a cause of action or a claim for relief to do that. under the Constitution that isn't part of the case. If to the extent it was relevant, again, that's something that should be put forth below so that there could be further factual development of the case. From what, I don't think that is their burden to do that in order to grant the relief that's requested with respect to the compact and the secretary's responsibilities. One other thing I wanted to point out with respect to the timeline of doing things. The legislature obviously showed itself that it could react, and it did react. The tribe's general council, which we also suggest should have approved this, shows that it showed it also could react very quickly. You addressed the issue with the government about the time frame, and they had plenty of time to anticipate this deadline coming and know the hard and fast consequences of the deadline passing. And it took in less than 1 month from the ratification procedures that they've implemented for the vote of the full general council on the water compact. It took them less than a month to draft those procedures and pass them in the legislature to the day of the vote for the initial referendum. So there's plenty of time. The tribe was very nimble, unlike maybe some other places, to move forward on this. So that shouldn't have been an
Thank you very
impediment
much,
to the
Council.
government. Okay.
You're over your rebuttal.
Okay.
Any of my colleagues don't have any further questions? Thank you very much to both counsel. The case is submitted.
Okay, thank you, Your Honor.
Honorable Court now stands adjourned until Thursday, December 12th at 9:30 a.m.